That's us now live.
Okay, just starting the meeting off, I'd just like to confirm who's in attendance and who's going to lead the discussion for each of the parties. For those intending to speak, can I please ask you to switch on your video? I think most of you have your video on, who I can see on the screen just now, if you're happy to do so. And for those just observing, can you please switch off your video? So first, starting with the applicant, the Community Wind Farm Limited, could I ask who's representing the applicant, please?
Yes, good morning. My name is David Hardy, that's Hardy. I'm counsel and I'm employed by Squire Patton Boggs within the specialist planning team here in Leeds. There are two other representatives who may or may not speak. I'll be leading the team, but two others on the call: Kirsty Kelshaw, who is legal counsel with Community Wind Power, and then Keith Campbell, who's a senior associate with my instructing solicitor, CMS Cameron McKenna.
Thank you, Mr. Hardy. Moving on to Scottish Borders Council, who's representing Scottish Borders?
Morning, ma'am. My name is Ron Kirk. I'm a solicitor with Scottish Borders Council. I will be representing the council. I have with me Scott Shearer, who's a planning officer. I may have to defer to him if some of the discussion gets a bit technical. I also have with me on the call, but they won't be taking any part in the proceedings. They're just really shadowing me. I have a couple of colleagues, Fraser Rankin, who's a solicitor within the legal team at the Scottish Borders Council, and Morgan Harris, who's a trainee solicitor within the legal team at Scottish Borders Council as well.
Okay, thank you, Mr. Kirk. And Dumfries and Galloway Council, who's representing them?
Ma'am, good morning. My name is Douglas Armstrong. I'm Queen's Counsel and a member of the Faculty of Advocates, and I'm representing Dumfries and Galloway Council this morning. I'm instructed by Laura Whitelaw, solicitor at Dumfries and Galloway Council, who's also present, and Robert Duncan, the team leader of major developments in the planning department, is also present this morning.
Okay, I understand Robert's standing in for Chris McTeer, I think it is.
That's correct, Ma'am.
Okay, I'll just note that down. And then on behalf of Historic Environment Scotland, I understand, is it Mr. Gregg of Morton Fraser representing their interests?
Ma'am, I'm appearing this morning, yes, Douglas Milne, partner at Morton Fraser, representing Historic Environment Scotland. And this morning I am accompanied by my colleague, Mr. Gregg, and also by Adele Shaw and Ursula Savsinka, both of Historic Environment Scotland. Mr. Gregg and Historic Environment Scotland are with me in our boardroom, but we are socially distanced.
Okay, thank you. Mr. Milne, you're also representing Ministry of Defence.
That's correct. Now, ma'am, just to be clear, the Ministry of Defence is instructing senior counsel for this inquiry. So Ms. Ruth Crawford QC will be appearing at the actual inquiry, but unfortunately Ms. Crawford is not available today. We are joined online, but not participating in the proceedings, by my colleague Susan Leslie and also by Mr. Desmond Egan of the Defence Infrastructure Organisation.
Okay, thank you. Now, moving on to some of the other interested parties. I've got Upper Liddesdale and Hermitage Community Council. Do we have a Mr. Kolb, Geoffrey Kolb, present today?
Yes, good morning, ma'am. My name is Geoffrey Colby. I'm the chairman of Upper Liddesdale and Hermitage Community Council.
Thank you. And representing Fullside Community Group, Mr. Campbell.
Good morning, ma'am. I'm John Campbell. I'm Queen's Counsel at the Scottish Bar, representing the Fullside Community Group. With me today, but not visible, are Yvonne Jackson and John Beachy, and for all I know, others who have plugged into the video.
Okay, I've noted this. Can I just check with you, Mr. Campbell, is Mr. Beachy's interests in relation to the community group, are you representing his interests as well?
Mr. Beachy is the administrator of the community group.
Okay.
And the point of contact for mail.
Great, thank you for clarifying that. Right, the next party I have is Johnny Armstrong Gallery and Borderlands Museum and others. Mr. Moffat.
That's myself, yes. I'll be representing the Borderlands Museum. We're a private enterprise and we've been operating in cultural heritage for over 40 years now.
And you're also representing United Borderlands Historic Trust and the Teviot Dark Sky body as well. Yeah.
United Borderlands Historic Trust is a charitable spin-off of the Borderlands Museum, and Teviot Dark Sky is a community group which is hoping to get national dark sky status for the old parish of Teviot Head.
Thank you.
Might I ask if the minutes will be available of everybody who's attending? I'm just scribbling everybody's names down here. It might be easier if
yeah, I will cover that fully in my note of the meeting. I'll note down everybody that was in attendance.
Okay, thank you.
I think Mr. McClyman has joined us. Mr. McClyman, have you joined the call?
Yes, I'm joined now. Yes, I had a problem there earlier on. It just repeatedly said hang tight, we're opening the Microsoft Teams.
Right.
So I kind of waited 10 minutes and then went back to try and link in again, and it happened second time. Thank you.
Good. Okay. I understand you want to keep your video off. That's absolutely fine. We can hear you perfectly well, and that's okay. I've started the meeting. All I'm doing at the moment is just getting parties to introduce themselves. So could I ask you to do that, please?
Yes, my name is Alexander McClyman, and I live at 23 Linden Avenue, Girvan, Ayrshire, Scotland.
Okay, thank you very much. I have a couple of other people on the call. Mr. Mandel, you've joined us as well now, I think, also representing the community. If you could just introduce yourself.
Yeah, Oliver Mundell, member of the Scottish Parliament for Dumfriesshire, and I hope to participate on behalf of constituents.
And I have one final party who is Mr. Hanrahan.
Yes, good morning. I represent, well, we own some holiday cottages which will be affected, and I'm also representing the Langham Initiative, which is a community development trust, which is a charity in Langham, and I'm deputy chair of the charity, and we raised £3.8 million last year to acquire 5,200 acres from Buccleuch Estates. And we're presently in the process of endeavouring to raise an additional 2.2 million from Buccleuch Estates for an additional 5,300 acres. And we have a deadline to achieve that in May this year.
Can I just get the name of the charity trust there? What was the
Langham Initiative.
Okay, thank you. Now, I don't have anybody else on the call today. If anybody is present that representing any of the party, please speak up just now. Okay, don't see any hands going up. A number of the community representatives are not in attendance, but have indicated that they wish to take part in the inquiry. And these are, we've mentioned John Beachy of Forside Community Group, and Mr. Stephen Lucking, and also Ian and Alana MacDonald, who are local residents. So they're not on the call today, but they have indicated an indication that they want to take part. So I'll be in touch with them separately. No other party at this stage has indicated an intention to participate in the inquiry, as far as I'm aware. Okay, just moving on to the next item in the agenda. So I'm going to touch on the Code of Practice. Now, the Electricity Act dates way back from 1989. And it doesn't actually say very much about the procedures that are to be followed in public inquiries dealing with these cases. In 2009, the appeal procedure rules were introduced, which changed and modernised the way in which we deal with planning appeal cases and applications called in by Scottish ministers. And the changes that we introduced at that point were to enable parties to be involved in a very transparent and fair way, and that the process is transparent and fair. And that the procedures that we adopt are proportionate and efficient. And certainly in the last couple of years, we've been putting had to put some of that into practice. The DPA has for some time now applied the spirit of this approach to a wider range of casework, and that includes Section 36 cases. we published a code of practice for handling inquiries under the Electricity Act. I think I put a link of that into the agenda. And it's my intention to follow the code of practice, which is normal practice with these cases. Now, before I move on, can I just check? Does anybody have any objection to us proceeding on that basis using the code of practice? Okay, thank you. The next thing I'm going to go on to, item 4, is on updates to parties' positions, and there has been a little bit of correspondence over the last few days, which I'll come on to. So I'm thinking up here of any updates that people have in relation to their general positions that I wouldn't be aware of, or how things maybe have moved on since the original information was submitted to Energy Consents. So the first thing that's been flagged up to me, and one thing I flagged up in the agenda, is we've had an objection that's been submitted by Dumfries and Galloway Council. And so I'm wondering here if the applicant has submitted a position statement in which they've responded generally to their position as far as the current, so far in terms of the representations that have been submitted. Given Dumfries and Galloway's objection, is there an intention by the applicant to update their position statement?
Then yes, we would like the opportunity to do that. Sorry, it looked as though my video stream just froze.
It did, yes.
For a second there. I don't know if you got the answer, but yes, we would like the opportunity to do that.
Okay, could I ask, given where we are, I think the last position statement you provided was the end of 31st of January. Would you be able to do that within the next 7 days?
Yes, let's say, I'll say yes.
Thank you, that would be helpful. I think you updated it at the end of January in response to Historic Environment Scotland's comments.
Correct.
But there are a range of matters now that have been raised by Dumfries and Galloway that I would like to expand your position on. Okay, that's fine. I'll put that, well, in fact, if it's going to be 7 days from now, if I could make that instruction now, but I'll note it in the pre-examination meeting minutes as well. Now, the second item, I believe the applicant wishes to ask that I seek additional environmental information for the purpose of the inquiry relating to nighttime visualisations. This is to show the effect of a revised aviation lighting strategy approved by the Civil Aviation Authority, which involves a reduction in the number of lit turbines, and it would assist the consideration of the landscape and visual impacts. Now, could you maybe just tell me a little bit more about that, Mr. Hardy?
Yes, so our view is that revised nighttime visualisations would, showing the revised aviation lighting scheme, would be a benefit to all parties, particularly yourself, in examining the effects of that revised nighttime lighting scheme. Clearly, the sensible thing to do is that is under the regulations, and therefore that's what we're proposing. In terms of timescale, we're suggesting that that's aligned with the submission of the core documents list and draft conditions, and we're proposing that ought to be mid to late April. That will, we say, allow substantial time for review by the other parties prior to the inquiry statements and precognitions being submitted. So yes, under the EIA procedure, and in terms of timescale, mid to late April, please.
Okay, so you're looking at the timescale under the same time as the core documents list.
Yes.
Okay. Yeah, so we're roughly, the core documents list was 12 weeks before the inquiry, so around the 4th of April. So that's a little bit earlier than you're suggesting.
Yeah, well, I said mid to late April. If it could be pushed back a little bit, that would be helpful to us. We're already, we're mid-Feb. So to make sure everything's done properly, we think that would still allow enough time for review. So if we could put that back by a week or two into April.
Okay, I can understand the suggestion, and under Regulation 19, there was an ability for me to ask for additional environmental information in accordance with the purposes of information that will be heard at the inquiry. We have a landscape and visual impact session on which an item I've identified is nighttime lighting. and it's a matter that I would like to cover at the inquiry. So I think it's a reasonable request that is put forward, and I will initiate that as a separate matter through the office.
Thank you very much.
The other item that has been raised with me, I think it was just yesterday evening, is a matter Mr. Campbell you've raised on behalf of Foresight Community Group, which is a request for wireframes of, is it Glendivon Farm and Glendivon Cottage? So wireframe visibility images for these properties. Could you tell me a little bit more about that request?
You'll be aware, ma'am. Yes, I will. Thank you. You'll be aware that there is a residential visual amenity assessment as part of the applicant's documentation that is expressed in relation to any residences within 2 kilometres of the wind farm. Glendivon Farm and Glendivon Cottage fall just outside the 2 kilometre margin. On the 3rd of January, I asked my friend, Mr. Keith Campbell, to ask his clients to provide wireframes from these 2 properties. Yesterday, I received an email from him indicating his clients had decided not to accede to my request. And accordingly, I make the request now that they be directed to provide these wireframes under Regulation 19. It's a very simple matter, ma'am. Doesn't require a site visit or site inspection or anything, simply the production of computerized wireline drawings from these 2 residences. They will see between 10 and 18 turbines in whole or in part. So this is not a peripheral request, but a substantial request. I'm sure that my learned friend, Mr. Campbell, understands, beg your pardon, my learned friend, Mr. Hardy, understands the importance of this to those who live just on the outside of the 2 kilometre perimeter. And it will determine, of course, whether or not an objection on visual grounds should be maintained from these 2 residences. I hope that's clear.
Yes, it is. Mr. Hardy, do you want to respond to that?
Yes. I mean, production of evidence has got to be proportionate and in compliance with guidelines and best practice. So the RVAA guidance suggests a 2 kilometre threshold, and based on general practice that it's unlikely to be of significance beyond that point. So that's the reason. It's not been, there's nothing more to it than that. There has to be a cut-off. These are at 2.5 kilometres. In terms of the request that was made, what was pointed out was that at this late stage, that would be that was inappropriate outside of the EIA process. And of course, Mr. Campbell wanted to make a request, and he could do so as he is now doing at the meeting. So if it's going to come in then in a similar way to the nighttime visualizations, then that ought to come in under the under Regulation 19. We say it's not necessary. The viewpoints were agreed. It will be a matter for you. All I would say is if wirelines are to be produced, then my client would like to have visualizations prepared as well, because they will show the real life situation, including screening. So if the wirelines come in, then we'd also like provision to be made for visualizations, but we say that neither are required for you to be able to come to a proper view in relation to RVAA in response to current guidance.
Okay, thank you. Mr. Milne, I notice you've got your hand up.
Yes, thank you, ma'am. As regards the Ministry of Defence, I assume that you have a copy of the letter sent to DPEA by the Defence Infrastructure Organisation on the 16th of February. So to double check that you are aware of the withdrawal of that part of the MOD's objection, which relates to impact on threat radar. The MOD is maintaining its objection as regards impact on the Castleweary seismic array, and is also maintaining its request for conditions to be attached to the consent. As regards the threat radar objection, now withdrawn on that conditional basis, and as regards aviation lighting and aviation charting and safety management. As regards the Castleweary array objection, which is being maintained, I have been discussing matters directly with Mr. Campbell of CMS on behalf of the applicant. Ma'am, as I think you're aware, the applicant has prepared a report which explains their position as regards the MOD objection. That report is with the MOD and is being considered. The applicant has recently undertaken to make a number of revisals to the report, which will then enable the MOD to make a formal response. The content of the report and the MOD's response is obviously going to shape the evidence which is ultimately led before this inquiry. And I think it would be of very considerable assistance, essential indeed for parties to update their respective position statements. Again, I've discussed with Mr. Campbell, perhaps that could be done by way of an exchange of letters. Without that happening relatively soon, I have a concern which I understand Mr. Campbell shares. Mr. Hardy can obviously speak to the applicant's position, but that there is a risk of not having early clarity as to what parties' respective positions are in a technically very complex area. So I don't know the date by which the MOD will be able to respond to the updated report, because we don't have the updated report yet. I understand that it's imminent. I'm also concerned about making a request for a formal deadline to be imposed upon the MOD, not just because we don't have the report yet, but that there is a single individual at the Atomic Weapons Establishment who will be responsible for reviewing that report, and his time is in very short supply. So I had suggested directly to the applicant that perhaps leaving it between the parties at the moment to provide, to correspond with each other, and then to provide an update to you, ma'am, as soon as possible regarding more detail as to parties' respective positions would be an appropriate way of proceeding.
Ma'am, forgive me. I don't know whether Mr. Milne was, unable to hear the stream. I thought we were talking about visualisations in relation to Glendiven Farm and Glendiven Cottage. We hadn't actually sorted that out. We do have lots to say.
I will come back to that. Yeah,
we have lots.
Yeah.
Well,
if you could just, would you mind responding to just the matter there in terms of the MOD's objections?
Well, if I may, could we do it the other way around? There's a lot to say in relation to the MOD. Okay. Mr. Campbell had put a request in, to be fair to him, in relation to the wire lines. I wonder whether it's better to sort that out. Then we could move on to the MOD. I wasn't expecting Mr. Milne to come up to jump in with those sorts of points.
Yeah. My apologies. I thought Mr. Milne had raised a question regarding the visualisations. So
yes, no, it obviously
jumped onto another matter. Yeah, that's okay. Yeah. All right. Let's just step back to the discussion we were having around the wire lines and your suggestion that need to be visualisations, but actually your view is that they're unnecessary. My point, I think, at this stage is if we're looking at getting wire lines for properties that are more than 2 kilometres, I think you've mentioned these are around 2.5 kilometres from the turbines. Does that not then initiate perhaps other properties and raise the matter for other properties that might also be within that particular threshold of the turbines? And I'm concerned about extending this further. Could you maybe respond, Mr. Campbell, on that in terms of further explanation?
Certainly, the request was made on the basis that the 2 residences, and you know that this is an area with very isolated residences, that the 2 residences are just outside the 2-kilometre perimeter. And of course, it depends where you start the perimeter from, because a wind farm is not a single point. So on grounds of cooperation, which we expect to see from renewables developers, it seems to us that the production of a wireframe from these 2 residences is not an outlandish request. Mm-hmm. If you refuse the request, ma'am, which you're quite entitled to do, of course, I will have it done, but I will make an application for costs of doing so. That is my reasoning, and I hope it's satisfactory.
Mr. Hardy, could I just ask, how many are a number of properties? I'm not familiar with all the properties in the area. Perhaps you will be, or one of your colleagues will be, as to how many other properties potentially. We're talking about, quite a significant number of turbines that are visible from these 2 properties, between 10 and 18 turbines. Are there any other circumstances that you're aware of where that's a similar situation?
I'd have to take instructions on that, but I do know this, that Glendivon Farm and Glenwood Cottage are 2.5 kilometres from the nearest turbine. So that's the measurement that we've got. And, you know, I repeat the point that guidance that's been prepared, there is updated guidance in relation to preparation of RVAA sets a 2 kilometre threshold. So it's got to be proportionate. And I'm afraid I don't think it would be unreasonable if we don't, because we are complying with what is deemed to be best practice. Of course, it's up to you to say, well, like, you know, it is only just best practice if you feel you want to go beyond that. But there is a danger in opening that door, and we just remain of the view that you don't need it.
Okay. If there's nothing further on that, I would like, given that this has just popped up literally yesterday evening in my email box, so I haven't had an opportunity to really even see where these properties are or really look at the background information. I'd like some time to think about it. And I will make a note in the meeting as to what my decision on that will be. I've
got Mr. Welch, who's the landscape witness on the call. He's watching, and I can just set him a little bit of homework to say, look, could you have a look to see how many other properties might be in that type of range if we set out to 3 kilometres, say, so in that 2 to 3K. So that will inform you to the extent to which it might be opening the door.
Yeah, and roughly how many number of turbines that are visible from those? I appreciate them. There might be just blade tips or larger amounts of turbines that might be visible from those. But that would just give a bit of context, I think, to have a
yes. Okay, we'll try and do that to be helpful. Also, I'm just reminded that it would require a site visit. So if you were going to form the view that those were required, we'd just ask you, Mr. Campbell, through you, to agree to access for Mr. Welch to go to those properties.
Okay.
Yes, of course he can have access to the properties. You'll be aware, ma'am, that the RVAA, in inverted commas, rules are not prescriptive. They're guidance issued by a professional institution and largely adopted by renewables developers in the spirit in which they are written, which is to make an informed qualitative assessment of the visual impact on residential properties. Not an exact science. And I'm sorry to say that I find Mr. Hardy's Mr. Hardy's client's approach to this really extraordinary. However, we are where we are, and we look forward to your decision, ma'am.
Okay, thank you. Leave that with me, thanks. And I'll have that information from you, from the applicant, Mr. Hardy, as soon as you're able to provide that for me to make that decision in the next couple of days, if you can. Yes, okay. Right, moving on to, yes, Mr. Milne's explanation there as to the position and what sounds like. Now, just so I can understand, there's an updated report that's being prepared, which needs to find its way over to the MOD, and then there's obviously a period of time in which there needs to be, it sounds like there still needs to be quite a bit of liaison between the parties on this. So, Mr. Hardy, could you just come in on that in terms of what's your understanding of where things are at?
Well, so there are 3 different aspects to the MOD case. Let me deal with those in order. So threat radar, first of all. The objection has been removed by the MOD, subject to imposition of a condition which was noted in the MOD's updated position letter of the 16th of February. And that I think is common ground. So the threat radar objection removed. The second part then is in relation to aviation lighting. That objection removed by the MOD, subject to imposition of a condition noted again in the MOD's updated position letter of the 16th of February of this year. We then have the MOD's letter of the 22nd of February confirming acceptability of the proposed revised aviation lighting scheme itself. And I can report too that that revised aviation lighting scheme was approved by the Civil Aviation Authority on the 17th of February, following previous CAA approval on the 21st of December 2021. There's some toing and froing in relation to proposed aviation lighting condition, but that's not a matter that need detainers now. That can be ironed out. So those two are straightforward and resolved. Seismic array, then clearly the MOD maintains its objection. The Heriot Watt report is with my client's technical experts. It's being peer reviewed at the moment. There are certain minor amendments being made following discussions with the MOD. It is anticipated that it will be returned to the MOD in the next few days. The language I've heard is imminently, and that will form the basis then of ongoing discussion with the MOD. The Heriot Watt report, once finalised, it is envisaged will be submitted as an inquiry document. So at the moment is in confidential form, and understandably so, but at the point when that becomes crystallised, then that it'll be necessary to submit that as an inquiry document and put it into the public domain.
Okay, thank you. Just checking I've got the correspondence. So I have a letter from the MOD, well, Defence Infrastructure Organisation, dated 16th of February.
Yes, that's it.
Yeah, that's the latest correspondence I have, which has got the suggested conditions in Annex B, the aviation lighting and the aviation charting and safety management. And then the Annex A, which has got the other condition in to do with the electronic warfare, warfare training, which is the threat radar. Got you. Okay. Right. It sounds like there's still ongoing discussions. I think what I can ask you to do is just keep me updated as much as possible in terms of how these discussions are ongoing. There's still a little bit of time between now and when the inquiry documents will be required. I think I've got in this my agenda, I'm going to come on to the dates for which I'll be expecting various things to come in. This is assuming we start the inquiry towards the end of June, and we'll come on to that. So I will cover that later in terms of the timescales and see if that fits in generally with what's happening. And I appreciate, Mr. Milne, that you've got to get people from the MOD involved as well at various stages and specialists involved in the timescales for that. Hopefully there's enough lead-in time between now and the start of the inquiry in the summer.
Yes, ma'am.
Go on, Mr. Milne.
Yes, I certainly hope there is, but that's what informed my comment about, certainly in the first instance, I think the less formal exchanges without seeking an order from you, ma'am, are an appropriate way of proceeding. But obviously what's underlying my concern here is, particularly given the very technical nature of this issue, that what I absolutely must ensure that the MOD avoids is getting close to deadlines for the submission of inquiry statements, for example, and there's a degree of uncertainty. This works both ways. I appreciate that, but we must ensure there isn't a degree of uncertainty as to what parties' respective positions are. But I'm sure we can work together on that, see where agreement can be reached, see where there are matters of disagreement, work on a statement of agreed matters if that's considered to be helpful, and keep you advised, ma'am, and if any formal orders are required, then either party can seek that. The one point which comes out of that, which I just want to make sure there's no misunderstanding. I hear what Mr. Hardy says about the Heriot Watt University report currently being of confidential status, whilst it remains perhaps in draft form. To be clear, the MOD does not wish to be constrained in its ability to respond to that report and to provide you, ma'am, with an update, which is obviously going to involve making references to what is in that report, the updated report, which is due imminently, and the MOD will proceed on the basis that it can give a full response.
Okay. Yeah, if you could proceed on that basis and involve me as you think in terms of updating me in terms of the progress of where things are at, in the next few weeks. I think my main issue is I want to really understand what the key differences are between the two parties and really get to that. So I will add, as a matter of statement of agreement, if we can have some of the matters in agreement in there and what the key areas that are in conflict between you at that stage. But please, if you could keep me informed, not with the full details of what's going on between yourselves, that can happen without my direct involvement.
If I may, I agree with what Mr. Moan has said. My client has already agreed that a statement of agreed matters would be a good idea. I think between us, and this does have a consequence for timing of the inquiry and length and duration of the inquiry, is that we think that 4 days is likely to be needed for the seismic array discussion. And I know the MOD have proposed that through Mr. Moan to the unit, and we respectfully agree. So even with the level of agreement that we're hoping to achieve, based on past experience and knowing the issue, we think 4 days is going to be required.
Okay. I was going to raise that later on, as you've raised it now. It was a question really back to you, really, about 4 days. It seems quite a long time for one issue where we only have two parties involved. But I haven't been involved in this particular issue in any detail at an inquiry session before. I've had it as an objection and a matter to be observed.
Dare I say, and you're probably grown at this, but 4 days is actually fairly tight for this issue. It is highly technical. So 4 days, I think, it's got to be proportionate, but 4 days is going to be required even with a high level of agreement and working together between the parties. So that does have, I'm afraid, an immovable consequence for the rest of the inquiry. And we'll come on to that, but I think it pushes this inquiry into a third week.
Yeah. Okay, I hear what you're saying.
Yeah. Ma'am, I would add agreement there, past experience of dealing with Estelmuir array matters at inquiry, although the matters have not been considered at inquiry over the past few years, is that yes, 4 days is tight. There's also primarily this is the technical issue to do with the seismological capability of the array. But there is a evolving policy background as well, which the MOD considers is important to ensure you have a proper understanding of the issues. Now, it could and should be that, again, a lot of that is capable of agreement, but that's what parties, in my view, will need to work on as well. Regardless of the level of agreement, I do agree with Mr. Hardy. 4 days is tight. I think the last time this issue came up to inquiry, it tripped into a second week. I understand that Mr. Hardy, and you do come on to this later, ma'am, in your agenda, will have something to say about the benefit of this inquiry session taking place in person. Again, given the fairly exceptional nature of the issue, which we will all be discussing.
Okay, if we could,
in short,
on to that
yes.
a bit later.
I mean, if it helps now, 4 day. I mean, we've got to keep it. It has to be proportionate. It will be 4 days in our view, and we need to tailor evidence to that. But 4 days in person, we think, is sensible.
Okay, we'll come on to that. I'll maybe get a little bit more information from you as to why that is preferred. Okay, so there's 3 items there for me to have a look at. Is there any more updates to parties' positions that I need to understand?
Perhaps,
okay. Is Mr. Moffat?
Yeah, I'm just going to have to raise a hand. I'll raise a hand. With regard to our expression, I've never been to an inquiry before or attended one. We would like to do a visual display to represent the cultural heritage of the region. And I was wondering how that could be facilitated within this inquiry. Also, most of these inquiries seem to talk about technical matters. And we at the Borderlands Museum, as I say, we've been operating for over 40 years now. I'm second generation. And what we're able to do at the Borderlands Museum is represent the intangible cultural heritage of the region. We can demonstrate historic artifacts from the Iron Age right through the Dark Ages through to the age of the Reavers. and we can demonstrate artefacts related to the landscape, which we have. This isn't a conventional approach to a public inquiry, as far as I can see, but within your inquiry, I think it's absolutely important that we can represent the cultural importance and the heritage of the region, which otherwise won't be represented. In recent months, last year, we've been taking aerial drone photography of the Teviot Head volcanic complex, which is a volcanic cluster, which is of international importance, and it straddles the whole region of Forside. And we would like to be given the opportunity to demonstrate that in its full capacity, if you see what I mean. Would you be able to do this with an inquiry?
I will have a think about it. Obviously, visual representation of information is possible via this medium, so there's ways of doing things. I think I would have to ask my technical support to have a think about how we could do that reasonably. Obviously, within the bounds of your representation and within the bounds of looking at what the impact of the proposal is relative to these these cultural heritage assets that you talk about. It's really, I think it's important that I understand what you consider to be the concerns of the proposals, rather than I understand you want to give me more of a more of a general overview of an understanding of the area as a whole?
It's absolutely critical to the understanding of this region that its cultural importance has to be expressed. And I don't believe that there's anybody else who has the ability or understanding or the facility to do that other than ourselves, with 40 years of experience in this region. We've put together a slideshow of images so we can present that within a 2-hour slot. Now, I'm self-employed. We've got a lot of pressure on business, and my time's in very short supply, but I can't express enough how critical it is to an understanding of this region that we can demonstrate the cultural heritage, which is in danger of permanent destruction as a consequence of this wind farm application.
Is it, given that we're going to be having a specific cultural heritage inquiry session involving Historic Environment Scotland and the two councils involved with the applicant, is it your intention to be involved in that particular session? I've noted you down for kind of being involved in a community issues session, but does it extend into there as well, or mainly?
That would be the prime position for us to hold, really, and that's central to what we do. The Dark Sky is also a community project, but essentially it's the cultural heritage, which would be the main sort of thrust of what we would want to represent, and what we have to represent, which has to be represented in your inquiry.
Mm-hmm. Yeah, I mean, obviously, if there are common areas and common issues, what we try to do is get people to combine their efforts so that I'm not hearing duplicate evidence, and we're making the most efficient use of the time that we have at the inquiry. Would it be possible for you to touch base with perhaps the other parties who have objections around cultural heritage and see if there's something there that could assist my understanding of what those matters are?
Absolutely. We have been in constant contact with Historic Environment Scotland for, as I say, for 40 years, with successive local archaeologists in the local council. We've been in touch with all the main players within the historic environment over 40 years. As I say, I'm second generation, and we can absolutely put together the cultural identity of this region.
Mm-hmm. Okay.
We'll have to be allowed to do so. And as I say, our time's very limited, as is everybody's. But any time I take off work, when I come back home, I've still got to do all the work. So ideally, which I have to do anyway, so if you're able to facilitate a 2-hour session with audio visual, that would be fantastic. And it would be fantastic for everybody to understand what the region actually is.
Okay. No, I appreciate that. Thank you very much. I will give that some thought and discuss that internally in terms of how we might be able to hold something of that nature. And also, yeah, I would really encourage you to work with the other parties if you're intending to be involved in what looks like probably a cultural heritage sessions now running over 2 days, I think, rather than 1 day. That was my thinking before coming into the meeting today. Now, I've got a couple more hands up. I think Mr. Campbell, is it on that particular issue or is it on another matter?
No, it's on that issue, ma'am.
Okay,
just to report to you that I have made preliminary contact with Mr. Moffat, as have my clients. There's no agreement yet that we should share representation, but I anticipate that that might be the subject of discussion. And taking on board what you say about the desirability of parties combining their efforts where possible, I can assure you that that will be undertaken. Whether it's successful or not remains to be seen.
Okay, I would encourage that. Thank you. Mr. Mundell, you've got your hand up.
Yeah, it was just on this point, and it's a slightly sort of unusual thing perhaps, but I had wondered about the possibility of you visiting the museum to see some of the artefacts in person as part of an accompanied site visit. I think that would give you, I don't want to dispute the sort of expert evidence, but I think seeing some of these objects briefly in person would give you a good feel for the strength of feeling on the ground locally about protecting that heritage.
Yeah, there's no reason, I think. Are there any objections to me visiting on an accompanied basis? This would be when we do our site inspection, the actual museum?
At present, we're in the process of renovation and building. Obviously, we went through a 2-year period of COVID. We've taken that opportunity to rebuild and refurbish. This year, we're going to have to work like hell to get back to where we were pre-COVID. Everything's upside down in terms of open access to public visits, but I can absolutely make demonstrations through photography, which is what I was hoping to do at the inquiry. Artifacts are very difficult. We've got pieces which will be coming on loan for the spring. In terms of cabinets, we're getting cabinets made. The supply chain for glass, metal extrusions, etc. Everything's all set back with COVID. So a visit probably wouldn't be possible, but certainly I can absolutely make good demonstrations through visuals.
Okay, there sounds like there's something there. It wouldn't be until right into the summer, so we're talking probably August time before I would be intending to come to do a site inspection. But
certainly, please keep in touch, and yourself, who can make some a personal arrangement, but it wouldn't be in the full capacity. The chances ought to be not in the full capacity of the display, because I'll say that's a work in progress. It's a consequence of lifetimes of experience. This is a reinvention, really, of in the 1980s and 90s, we ran the Museum of Border Arms and Armour, specialising in 16th century Revan period artefacts. Since the 90s, we've run annual exhibitions of artefacts. What we're doing now this year is with the Borderlands Museum is a new venture, really, which combines all those years of experience. It's a huge task for a small business, but we're getting there. And this is the year when we hope to relaunch the Borderlands Museum in its full capacity, demonstrating folk art from the Iron Age, as I say, right through to the Revan period. But certainly, give us a shout. We can make some, make a personal sort of come down and have a look if you want. But that'll not be in a large public capacity, if you know what I mean.
Yeah, of course. I would need to be accompanied in some form if I were to come, but we'll sort something out. I certainly hear what you say about, in terms of the actual cultural heritage session itself, and maybe having some visualizations, visual display there in some form. Yeah. If we could just leave that, there's obviously matters of detail that can be discussed. If no one has any general objection to that, Mr. Hardy, do you want to come in just on behalf of the applicant?
Very briefly. I mean, clearly you've got to be fully informed, and I hear exactly what Mr. Moffat's got to say, but there's a slight alarm bell ringing In terms of proportionality in time, you'll have seen that the cultural heritage, and I'm absolutely not advocating that this inquiry is extended any further. That is absolutely not what I want. It's 2 days, and if it's a 2-hour slot, that's a morning or an afternoon, pretty much. You know that HES is involved, the councils are involved. There's a lot of representation, a lot of information on cultural heritage. In terms of, if I might put it like this, the impact analysis of these turbines, which is really what you need to know about in order to be able to make your recommendation. It rather sounds very interesting. I'm sure I'd be fascinated by it kind of at another time, but I wonder whether or how much of that general historical context is actually going to be of use to you in determining the impacts of these turbines. So I just ask proportionality, this we have to get on. And I just query whether or not that sort of presentation is actually going to help you.
Yeah, the point I raised was about in terms of the relative in the context of the application and my understanding of how that will impact on cultural heritage features. It sounds like we're not going to get to the bottom of today, and I don't want to we've got quite a lot of other stuff to discuss anyway. But I want to just put a marker down that that's something I will consider. I hear what you've suggested, Mr. Moffat, and I would encourage you to talk to the other parties involved in the cultural heritage session. In the meantime, we'll talk about it in the office, about how there might be some greater understanding on my point of view as to what the cultural heritage issues are. It is always one of those tricky areas trying to understand it. I'll see things on site. I'll have visual representation given to me in the submissions. Sometimes it's just trying to convey all of that in a very clear and understandable way is really what I'm looking for the best way we can do that. So if you could leave that with me, and we will look at that internally and get back to you, and I'll note that in the meeting.
I can assure you that we will make the best possible representation of the cultural heritage. You can rest assured that will happen if you will allow it.
Okay, thank you. Thanks very much. Right, I'm going to move us on now. Is there any other, because we're just on the updates and I want to get into talking about the actual sessions. Mr. Hardy, you've got your hand up, you just got one additional?
Yes, this is another topic. Yes, so this is L&V. So we've not really talked about this. I may as well just pick it up now in terms of updates, change position, and inevitably there have been some movements in the cumulative baseline.
Yes.
Now, we're not proposing necessarily that an update is done. I think the cutoff was probably 2018 or so. There hasn't been as much activity here as there have in other areas, as you'll be aware. So really, I think it's a matter for you, again, under the regulations. If you felt that an up-to-date cumulative baseline was necessary, then we'd ask you to request that information under the regulations as being necessary for the inquiry. We're not saying it's absolutely necessary, but we're saying there are changes. And if you want to have the most up-to-date position, then that's something that you may want to do.
Okay, thank you. It was a matter that I've noted for potential. Got any views on whether the cumulative? I'm not aware of what the cumulative position is since 2018, Mr. Campbell.
It is rather extraordinary, if I may say so, to hear an applicant's representative asking the reporter what evidence she would like him to lead. It is for the applicant to present its case with the relevant cumulative impacts assessed for the reporter in turn to consider and assess. It's out of order in my submission for the applicant to simply say, well, Mrs. Reporter, you just decide what you would produce. I don't find that to be appropriate.
Well, our position is the evidence is there, what we're saying, and it's not inappropriate at all. But there have been some changes. If it's felt that a completely up-to-date position is helpful to you, Mum, then it's a request that you can make under the regulations, and we've got time to do that. So, I mean, given the strength of what Mr. Campbell's just had to say, you may think that may be as a sensible thing to do. And if so, we can discuss timescale for presentation of that.
Can I just check with Scottish Borders and Dumfries and Galloway Council's views on the cumulative position? Do you think it would be advisable for me to get an up-to-date picture? Because I think the baseline mentioned there was 2018.
Yeah, okay, for Scottish Borders Council, it may assist, Mum, but obviously it's a matter for yourself.
Have there been some significant progress with wind farms in the area?
Yes.
Inevitably, there are applications, there are schemes which have come and gone. There are those which are in scoping. So new applications, I'm told. We've got Hops Rig on a resubmission, Logan Head on a resubmission, Little Hartfell resubmission, Scoop Hill, Hairstone South and Dare. So there are some. Listen, it feels.
Yeah, I think probably, sorry to interrupt you, Mr. Hardy, I think it would be helpful to get at least an up-to-date position of where some of the wind farms are. Certainly 2018 seems a little bit in the past for me. Now we're sitting in 2022, we're 4 years on. So we'll probably request that as part of the further written submissions.
I'm grateful for that. I've also just had Mr. Welch, he's done his calculation on the hoof that extending the RVAA outer ring to 3 kilometres would bring, I'm afraid, about 40 to 50 properties into consideration, plus the community of Bent Path. So it isn't, in our view, proportionate or realistic to do that. So when you come to your view on whether or not 2.5k should be included, we just ask you to bear that in mind.
I just point out, ma'am, that nobody suggested 3 kilometres.
Well,
no, the difficulty, though, Mr. Campbell, is if you extend beyond guidance, that's a position which the threshold in guidance is set. If you go beyond that, one person gets it done, then you clearly have to consider whether or not the other 40 or 50 people then say, well, if it's good for them, it's good for us. So our position remains that the guidance is set there for a reason. We comply with that. But you've heard my submissions on that, ma'am.
Yes, and the guidance was written when turbines were much smaller, Mr. Hardy, as you know, and I'm only asking for 2 wireframes in a spirit of cooperation.
That's not correct, Mr. Campbell. As you know, the guidelines were updated very recently. They are in accordance with modern-sized turbines.
OK, thank you. I see, Mr. Armstrong, you've got your hand up there.
Yes, ma'am. Just on the cumulative baseline and update, obviously the report to committee that the to Dumfries and Galloway Council report updates the position, and it was certainly the intention of the council to lead evidence on the updated cumulative position.
Okay. Right, the committee report dated January this year. So that committee report in January, just so I can check, Mr. Armstrong, has that got, are you telling me that that's got the updated position of, I'm just looking through some of the examples here, implemented consented developments plus those proposed and undetermined?
That's correct. It's paragraph 1.13 of the report sets out implemented and consented developments and then proposed undetermined developments.
And that's update as at that date?
I can confirm that. I'm not sure whether it's up to that very date, but it's the information that the author of the report had at that time.
Okay, thank you. I'll have a look at that and decide whether that is sufficient or whether I need to request anything further as written submissions. I've got a hand up for Mr. Mundell.
Yeah, I would just say to draw your attention to it, the Scoop Hill project mentioned is also from the same applicant, and it is very sizable, and I think it therefore would be inappropriate not to consider it as part of the cumulative impact when looking at this development, as the 3 developments, if you include Sanker 2, all have, all in my view have an interlinked impact on the Southern Uplands.
Okay, I see Scoop Hill is listed as on the committee report as
I mean, it's a very sizable new development. And secondly, in relation to the point regarding the 2.5 and 3 metres, again, it was absolutely a matter for you. But the topography, of the area means that there's a very significant difference, I would say, in the visual impact on Bentpath Village from what there would be on the two properties mentioned. And there's a difference between 40 properties, being within that radius and what they would actually be able to see. And I think, this is the first substantial point in which a member of public, through their representative, could ask for that information, and we haven't got 40 or 50 people asking for it. So, I don't, I think people locally are very well aware of this development. There are a lot of interested parties, and if people were looking for wireframes and visualisations from their address, I think you would probably know about it already. But that's, I just would wish to add that.
Okay, no, point noted. Thank you. Okay, right. Let's move us on to the actual topics to be addressed at the inquiry, and also the timescales as well. I want to just talk about the topics first of all, and my suggestions for procedure. So things have moved on, obviously, since I put the agenda out. A lot of discussions have been going offline as well about availability. So I'll do my best to try and understand where everybody's at in terms of their availability. But just on the topics, first of all, my provisional thoughts on the main topics to be examined. I think there's a general agreement that we need to have a session dealing with planning and energy policy, and that kind of high level understanding of what if there's been any changes, in particularly changes in national policy and other matters. Mr. Campbell, you have your hand up. Is it on that particular issue?
Sorry, just waiting for you to finish that particular issue. We would like to see an inquiry session on that issue, ma'am.
Yes.
The reason for that is this. If I may speak now, yeah?
Yes, go ahead, yes.
Yes. The applicant's representative, Mr. David Bell, makes a number of contentious assertions in his evidence. I wish to cross-examine him on those in detail. I don't I submit that it is not appropriate for that a matter of that importance to be the subject of a hearing session. By way of precedent, at Sanker 2 inquiry, which was recent and so far not determined, there was a hearing session on this topic when Mr. Bell faced off against Mr. Christopher Ford, who was the local witness, both experts in their own field. And it was frankly very unsatisfactory because it became just conversational and nobody was able to drive home hard questioning. Now, Mr. Ford sets out propositions in his evidence, which you will have seen already, which are 180 degrees opposed to what Mr. Bell says. And therefore, we have a highly contentious set of issues around the application of Scottish and UK energy policy. In my respectful submission, ma'am, this is a matter that does require cross-examination and would be appropriate for an inquiry session. I don't know whether my friend Mr. Hardy agrees with that, but we have discussed it.
Okay. Yes, no, my position hasn't changed. We resist that, Ma'am. And I'm a bit curious as to the references to evidence. I don't know whether Mr. Campbell's getting confused with another inquiry. Of course, there is no evidence yet from Mr. Bell or Mr. Ford. So he can't possibly be looking at the hard assumptions put forward by Mr. Bell, because not in this case anyway. A policy is normally dealt with by way of a hearing session. There's absolutely no difficulty with that. I attended the Sanker inquiry as the advocate for CWL there. My experience was rather different. I thought that worked extremely well. It's proportionate. I think what Mr. Campbell may be saying is that Mr. Ford, perhaps if he says what he was going to say, what he said then, was trying to raise issues which we didn't consider to be relevant. And it was an opportunity maybe that he felt he wanted to expand upon. So we don't think it's proportionate. We certainly don't want it. We think it's a hearing.
Okay. Right.
Nothing to add, ma'am. Nothing to add.
Okay, I will give that some consideration. My initial thoughts was that I was going to have a hearing session on that, really concentrating on really where the updates are in relation to policy, so that I can understand that and I can convey that to the Minister. As you're right, Mr Hardy, there isn't any evidence been led yet. I'm not aware of what the party's positions are in any detail on that. I think my view is I would like to continue to proceed with a hearing session on that. I've done hearings on in relation to policy matters before, and I found them very useful discussion. It's an opportunity for me to ask very direct questions and actually get a discussion going on certain matters. I appreciate there may be differences in there and there may be some areas where it's great, but I can explore that with the parties in a hearing session, perhaps in some ways easier than I can in an inquiry session. I expected the two councils also to take part in that hearing session. So that would be Dumfries and Galloway and Scottish Borders Council. Is that agreeable? Is that reasonable to expect both councils to be involved?
Yes, ma'am. Scottish Borders Council anticipated to be involved in the hearing session on energy and planning policy. So yes.
Mr Armstrong, the same for Dumfries and Galloway.
That's the same for Dumfries and Galloway. And again, in relation to, Ma'am, your Annex A, we agree with the provisional assessment as far as the sessions the council will be involved in, and as far as Annex B is concerned. Again, you correctly set out involvement and the order of presentation of cases.
Okay.
Ma'am, I'm sorry for showing the seeds. Sorry for showing the seeds of a little confusion by talking about evidence. The evidence, of course, is being written at the moment and it's not in front of this inquiry. However, ma'am, Mr. Bell is an experienced planning consultant. Evidence does. Not guilty. I'm sorry, that wasn't my job. His evidence does tend to reappear in the same form from inquiry to inquiry. So we think we know what he's going to say, and we differ significantly from it. And for your benefit and the Minister's benefit, it is my clear submission, and I make this, as an experienced counsel, it is my clear submission that you would benefit from a cross-examination session on energy policy in particular.
Okay, your point is noted, and I will consider it. My view at the moment is that I would prefer to have a hearing on that particular session. Now, Historic Environment Scotland have indicated that they want to participate on the matter of historic environment policy, but I wonder if, rather than bring Historic Environment Scotland in purely just to talk about that particular policy, whether that particular policy, high-level historic environment policy, could be covered in the cultural heritage session, perhaps.
Yes,
I don't know what your take
agree
is
with
on
that.
Yeah, Mr. Milne, would that sound reasonable approach?
Yeah, yes, it does. In other and recent inquiries, ma'am, the cultural heritage policy has been considered as part of the inquiry session, and Historic Environment Scotland has not had to attend the planning policy hearing sessions. So to have that approach here of it all dealt with at the cultural heritage inquiry session makes sense.
I think it would just make more sense in terms of trying to get everybody involved at the right times and getting availability. We might struggle perhaps to try and get that in that order. So, there's an issue as well about whether we run the policy and energy policy session in advance of all the other sessions or whether it comes afterwards. Is there any preference? I've put it as a session that we kick off with after I've done my introductions. But would it be advantageous to hear that evidence after perhaps a couple of the other sessions?
I think,
Mr. Hardy?
Well, behind the scenes, it has been extremely difficult working up a draft suggested timetable. And the difficulty is that, you get in the drop zone, don't you, for holidays, June, July, August. So I think it's led by availability, and there just has to be a bit of give and take from our side as well. It's not quite how we want it, but we just need to get on. So I think that planning and energy policy are certainly on the most advanced suggestion that we'd got, or will have to be first day.
Okay. Any objections to that? Right, I'll try and build that into the timetable. Mr. Mandel, you've got a hand up. Have you got a question?
Yeah, it was on a different matter, but I just wanted to indicate that I was hoping to come in on this item, so just whenever suits you and others.
On the policy session?
Not on the policy session, no, on the overall agenda item.
Okay, right. Well, if you want to, let me know when we get to a particular issue. Now, moving on to landscape and visual inquiry session, which I think is appropriate. And I've set out a number of issues there which I would like to explore as part of the inquiry session. They include the methodology, which I think has been raised in some of the objections in relation to looking at the quality of the visualizations and the selected viewpoints. So it's an understanding of the viewpoints that have been chosen, on what basis, and the scoping that was done to arrive at the particular viewpoints. I think I can't remember how many viewpoints there are. There's 20 plus anyway viewpoints that have been carried out as part of the assessment. Likely effects on landscape character, and this covers both council authorities, so Dumfries and Galloway and Scottish Borders. We've got the complication of both authorities and obviously the policy framework behind those. So you've got regional scenic area, you've got special landscape area and landscape character units and types as well, and units. Significance of visual impacts from viewpoints, obviously. Other visual impacts, and I've put in brackets from roads, but it could be from other points as well. Overall scale, height layout considerations. Microsighting has been raised, and I understand there's been a change to introduce, I think it's 100 metres microsighting that was put into the latest position of the applicant's submission. I think it did change, I think, from 200 metres and reduced to 100 metres. Perhaps explore that as part of the submissions. Any cumulative impacts, and I think Dumfries and Galloway have objected on cumulative impact grounds, but as I understand, Scottish Borders haven't. Is that correct? Mr. Kirk, can you just clarify, Scottish Borders hasn't raised any concerns regarding cumulative landscape impacts?
I don't think we have, ma'am, but I'll just check. If I could call in my colleague, Mr. Shearer, the planning officer, just to confirm that my understanding is indeed correct.
We think that's correct if it helps.
Yes, it is. Yes, that's correct, ma'am.
Okay, thank you for clarifying. But Mr. Armstrong, Dumfries and Galloway have raised cumulative impacts in terms of landscape.
That's correct, ma'am. And again, just in relation to your list whilst I'm on, as it were, we'd agree with all the bullet points that you set out there. Obviously, in relation to the other visual impacts, you've got roads, but obviously it's roads and recreational routes that we've made points on.
Okay, yep, they'll pick those up as well. And then the final bullet point there is to do with aviation lighting, which we touched on earlier, and proposed mitigation, which we may have a lot more information on by the time we get to the inquiry. Okay, Mr. Medell, you've raised your hand. Do you want to come in at this point?
Yeah, this is a great point to come in. Sorry, I was hoping it might be possible to take part in the landscape and visual session. I had indicated that I was planning to ask that to your office. I've done so previously in an inquiry on North Lowther and on Sanker 2, and I have a number of specific questions and points I wish to raise with the applicant's witness. I'd hope you'd appreciate it's more difficult for me as a directly elected representative to be represented by a community group. And I therefore kind of appreciate the chance to put those questions if they don't otherwise come up. And I'd envisage only taking 15 to 30 minutes maximum. Not trying to hijack the session. And I've dealt with the other parties on this call previously, and I'd hope that they would recognise that I did attend throughout. Those inquiries, made a serious attempt to participate within the spirit of the inquiry.
As a participant, you would be required to submit a recognition, so that would set out, the
yeah, no, I'd be very happy to do that, and I've done so before.
Okay. Okay. Any particular issues with that? Happy to incorporate that into the landscape and visual inquiry session. Okay. Mr. Hardy?
Well, yes. I say Mr. Mendel was at the Sanker inquiry. All I'd say, no disrespect, absolutely made very clear representations that it wasn't technical evidence, and that was the purpose of that inquiry session. So I just wonder whether or not it would be better to put Mr. Mundel's evidence in the community issues box, because that's as a general overview.
I would strongly object to that. I'm aware, of the landscape character. I'm aware of some of the, some of the issues relating to the interconnectivity, of existing and planned projects. I think I can, add something of value to you. And I feel as an elected representative, it's important because the council are slightly more constrained because they have to deal with all these applications, and they have to, they have to follow the correct, process and be careful not to prejudice future applications. And likewise, I think that the applicants, got a vested interest. I think there are some legitimate points I wish to raise, and you will see those in any recognition, and you'll be able to decide how much time that's worth spending on.
Well, I'm afraid that then makes my point even more strongly, because if the suggestion is that somehow there isn't objectivity on the part of an applicant because of vested interests, and the point being made that councils are bound to follow correct process, but perhaps Mr. Mundell doesn't feel obliged to do the same, that is very much in the flavour of a personal representation. And of course, Mr. Mundell, of course, that's right, is entitled to make that. But it seems to me that the L&V session ought to be for technical landscape and visual evidence, which is properly cross-examined, and then Mr. Mundell's personal informed lay representation, because that's Mr. Mundell, if I may finish, Mr. Mundell's representation is in that form of a personal overview, ought to be somewhere outside of that, because he's not going to be susceptible to technical cross-examination. He's not an expert. It wouldn't be appropriate to do that. So I think resist that. Not that he shouldn't be in the inquiry, of course, but he ought to be with the community issues. Mr. Mundell, do you want to come in?
Yeah, I do. I don't think I do appear in entirely personal capacity. I've been directly elected, by thousands of local residents to speak on their behalf. This matter is coming before Scottish Government ministers, who are accountable to the Scottish Parliament, of which I am a member, and I'm happy to give the commitment, to set out the points I wish to raise in advance, in detail, and I'll be guided by yourself if I'm permitted to take part on what would appropriately fall within the technical session, and what would better fit within the community session, which I'd be delighted to also take part in.
When we look at the bullet points that are listed there, and I don't want you to give me any details at this stage, I appreciate you won't have your case developed in terms of what you're going to say in detail, but what is it you intend to raise at the landscape and visual session?
I'm interested in looking at cumulative impact, and also on some of the arguments that the applicant has previously made in relation to other applications in terms of the availability of suitable locations within Dumfries and Galloway for large-scale wind farm development, and their interaction with the policies the council has previously set out for what would be appropriate in what character unit. I'm happy to set that out, in writing, but I mean, effectively, without going into the detail, at the Sanker 2 inquiry, Mr. Bell brought forward evidence that suggested that project had to go ahead because there weren't any other suitable locations for projects of that size, or that there was somehow a limit, on available locations. And I'm just interested, to probe those comments in relation to this project.
I suppose it's understanding information that I need to get out of the process. What I need to understand.
So what I would like to help you understand is that there appears to be a recognition by the likely landscape witness in this case that there is pressure within Dumfries and Galloway in terms of identifying suitable locations, for turbines of this size, and I think that connects across the three, and combined with the number of other projects in the work, that there is a very significant impact on the southern uplands.
Right, I can understand the cumulative impact and my considerations of that in this scheme and its cumulative impact. But it's I suppose my difficulty is that I'm not in a position to be able to explore in the round, the Dumfries and Galloway Scottish Borders context in terms of what ought to be happening in all of the sorts of areas. It's that I'm dealing with this particular proposal.
I understand that.
My recommendation to the Minister will be about this particular proposal. So I'm just wondering, that you might want to explore sort of wider areas that I might have to then bring you back into a much more confined.
I think it is relevant to the Minister. You can't have the same applicant come forward in multiple locations arguing that the visual impact in those locations should be overridden because there aren't suitable areas to develop, and then them continue to bring forward multiple applications and make the same case in each of them. And I believe that in this case, this particular parcel, of landscape should be protected. And effectively, in my view, the applicant has made that argument themselves by pursuing other projects and making the case there that other areas of the region are too difficult to develop because of the council's policy.
Yeah, okay. I understand where I still think you're making the point that there's the alternative schemes are something that I should be looking at as part of. I don't think you should be looking at alternatives. I don't think you should be looking at alternative schemes, but I think this scheme has to be viewed within the context of the other schemes that the applicant has brought forward when looking in particular at the cumulative impact and the value of the landscape character within the units that we're talking about for this scheme. Okay. And I want to ask Mr. Bell about that if possible. I've got a couple of hands up. Mr. Campbell, you've got your hand up. Can you want to go first?
Yes, just taking up a point made by my own friend Mr. Hardy. It's a false dichotomy in my submission to differentiate between technical evidence on landscape and visual impact and the evidence of a witness like Mr. Mundell, who is elected. It's a very central part of the guidance on landscape and visual impact that subjective analysis is important. And Mr. Mundell is as well placed as anybody, as we saw at Sanker too. Mr. Hardy and I had the advantage of being there, and you didn't, ma'am. But as we saw in that inquiry, his contribution was directly relevant to the landscape and visual impact evidence, which was given to the inquiry, both by laymen and professionals. So I just wish to support his position in relation to that.
Okay, thank you.
Ma'am.
Mr. Moffat, you've got your hand up as well.
Hi, I was just slightly confused. David Hardy, can you remind me who you are? Because you seem to be leading this inquiry. Is it Claire? Is it not your decision what gets made within this inquiry? I'm just slightly confused as to what David Hardy, is he leading the inquiry or is it yourself?
No, that's not the case. Mr. Armstrong, you've got your hand up.
Yes, just one point from that discussion and what Mr. Mundell was setting out, and I think Mr. Hardy's response. I did not understand that it was the applicant's case, certainly as set out in the applicant's planning statement, that there are no other sites and that accordingly there is a specific locational need for this proposal because of landscape and visual restraints on other sites. Now, if that was the applicant's case, then clearly that would be a matter that would require to take up some time at the inquiry. But my understanding is that's not the applicant's case, and that's why it's not one of the bullet points down for the inquiry session. I'm sure Mr. Hardy can clarify that just now.
Mr. Hardy, could you clarify?
Yes, I mean, Mr. Mundell misrepresents what was said at Sanker. In fact, got the wrong witness. It was Mr. Denny, not Mr. Bell. And actually, it isn't my recollection of what he's now said was what he said at Sanker. And I think, and so Mr. Armstrong is right what he's just said. And I think that the as I heard Mr. Mundell speak, it just made my point even more clearly, that it's a political overview point. Of course, he's entitled to make that. And I just was clear to distinguish between technical L&V evidence, which is going to assist you in that session, and then a community overview session. He absolutely is a politician and represents community views, but that seems to me to be the better place. Obviously, it's a matter for you. I'm not sure I can take it much further.
Mr. Cook.
Thank you, ma'am. This is a different tackle entirely. I just had a slight query about the running order for the inquiry. I know we seem to be ahead of Dumfries and Galloway Council, but I wonder, given that they have objections in terms of cumulative impact, whether it would be more appropriate for them to be lead authority, as it were. And also my understanding is that there are more of the potential turbines in the Dumfries and Galloway area as opposed to Scottish Borders Council area. And my experience of inquiries, admittedly not in this area, but with inquiries which have been the boundaries with the Scottish Borders and East Lothian, have been that the lead authority, as you were, would be the one where the most turbines are likely to be sited. I just raise that as a query.
Yeah, I mean, you're both involved and you both objected. So, I'm treating both equally, but I understand that Dumfries and Galloway has more turbines in the area and a slightly wider range of issues that they've raised. You've both raised cultural heritage issues, though, so they will both be covered. But Mr. Armstrong, you've got your hand up. Did you want to come in there?
Just on that point, I think there are obviously more points that Dumfries and Galloway Council make in relation to this proposal than Scottish Borders. And the normal process would be that we would go later on, I would submit, and that Scottish Borders would go first because they've got less to set out. And so that's why when I initially came back on this point, I said that as far as Annex B was concerned, I think you have got it in the right order, the participation, and that would be the sort of standard order in this type of case.
I'm happy either way. I mean, let's see what works. Mr. Kirk, did you want to come back in?
I'm not particularly precious about it. I would just flagging it up that it may assist because Dumfries and Galloway had more points. But equally, I accept what Mr. Armstrong is saying. That if that's the norm, I can only speak from my experience with other inquiries I've been involved in, which have been directly with East Lothian Council, and it always seems to be the way that the authority where the most turbines are sited are the ones who tend to be the lead authority, as it were. But I realise it's nothing that's set in stone in that regard.
Yeah, I mean, I'm not going to hear duplicate evidence because it will be very, specific to the particular areas that you're talking about and particular turbines and relative to that. So I don't mind it remaining in the order that it's in. I think we can work it, and if you're happy, we'll continue with that. Just on the matter in relation to Mr. Mundell participating in the inquiry session on landscape and visual matters, I would like to give that some more thought. I hear what both sides are saying about it, and I'm kind of wavering a bit as to what might be appropriate in terms of your involvement.
I would just ask you to look
yes.
at precedent, and the precedent generally is, that I have previously been allowed to take part in those sessions, and in neither case there haven't been serious objections at the time. And in terms of proportionality, all I would say is I'm looking to take up 15 to 30 minutes, of what's now looking to be, a 2-week, potentially 3-week inquiry. I'm not looking to hijack, proceedings by any measure. And I can give you the commitment today that if you did include me, I will be guided by you in terms of what's appropriate from my recognition, to include within that. And I'll be happy to, I'll be happy to be stopped and for you to suggest that any matters that fall out with the technical or more general landscape and visual bits be moved into the community issues hearing. I'm happy to give that commitment.
Thank you, Mr. Mundell. I've got a couple of hands up, Douglas Armstrong and Ron Kirk. Can you, Mr. Armstrong, do you want to come in?
Sorry, I should have lowered my hand. I hadn't.
Oh, right,
lowered
okay.
it.
Mr. Kirk, have you got another point to raise?
Similar to Mr. Armstrong, apologies, I should have lowered
okay.
my hand.
I have to look at all the screens that are up. Okay, yes, I would like to appreciate what you're saying, Mr. Mundell and President, and I would like to give that, for that very reason, I'd like to give it some consideration and talk to some colleagues in terms of how that's been handled elsewhere. Okay, so I think we can move on from landscape and visual session matters. We'll come back and talk about dates. So moving on to the next topic, which I have in my list, which is in relation to an inquiry session. Give me just a second. I'm trying to keep things in order. Dealing with cultural heritage. So essentially, the representations that have been submitted from the two councils and for Historic Environment Scotland are in relation to archaeological sites. They relate to scheduled monuments within Scottish Borders area and within Dumfries and Galloway, and affect particular turbines. But also there's representations that have been raised in relation to, I think this is from Dumfries and Galloway Council, I haven't noted here, about the archaeological survey itself, the methodology and baseline information. So slightly wider contextual issues in relation to that matter as well. I've noted it down as an inquiry session because of some of the technicalities around the topic. Does that seem reasonable? And do the topic headings seem reasonable in terms of going forward?
Yes.
Just ask Mr.
In
Hardy.
short, from our yes, in short.
Okay.
Yes, ma'am. I agree.
So who was speaking there, Mr. Campbell? Yes.
Yes, just to say I agree with Mr. Hardy.
Now, the parties that I've got involved, I have got a question mark about Mr. Campbell in relation to Fullside Community Group. Are you intended to take part in the Cultural Heritage session or not?
As presently instructed, yes, ma'am.
And on what particular matters are you concerned with on behalf of the community under those bullet points that I've just indicated?
I can't tell you because I haven't seen the evidence yet and it's being accumulated as we speak. I told you earlier on that there had been initial contact with Mr. Moffat. I don't know if that will be pursued or not, but I am told that there is archaeological expertise to bring to bear for this inquiry. Where it comes from and who it comes from, I can't say at the moment. But of course, I'll let you know as soon as possible.
Well, I suppose I'm basing this point in time, which is, the pre-examination meeting where have the representations in front of me. I'm basing on the representations that I've read so far in relation to the concerns, and these are the matters that have kind of popped out in terms of what I want to cover. So, if there's an unknown, what I'm not understanding is how extensive this session could be if a lot of other issues pop up that I'm not aware of.
Well, I don't think the issue is popping up. I think the Foresight Community Group wishes to contribute to the discussion about the archaeological value of this area.
So do we want to? Yeah. Sorry,
I will. Go on. Sorry.
Sorry, I was just about to say. So would it be? Are we talking about a separate topic that is dealing with the general context, archaeological context, historic background of the area? Is it just Scottish Borders, or is it Scottish Borders and Dumfries and Galloway? Is it the entire site, or are there specific areas?
I understand it's both areas, ma'am, right. But I can't say more than that at the moment. And you may take it, ma'am, that again, as having some experience in these matters, if the evidence that is placed before me appears to be peripheral or indeed irrelevant, then it won't be led, and I will let you know. In the 2019 objection, which is quite full from the Foresight Community Group, certain matters are covered, and as I'm instructed at the moment, those matters are to be revisited in the inquiry. I can bring those up and talk about them if you wish, but I don't think you really want to talk about issues.
Yeah, not at this stage. Okay, so we appear to have a bit of an unknown kind of quantity in terms of the extent of time that might be needed around cultural heritage issues. I appreciate, Mr. Moffat, you talked earlier on about wanting to do some visual representation of the general context of the area. So I'm going to give that some consideration as part of the session as well. Mr. Armstrong, you've got your hand up. Did you want to come in?
Yes, ma'am. Just in relation to your three bullet points for this session, we would suggest that there should be a fourth bullet point on the indirect impacts on the prehistoric settlements and forts. That's an issue that's dealt with in some detail on pages 6 to 10 of the memo of the 18th April 2020 from the Council's archaeologist. Now, there has been, I'm sure you're familiar, there has been a response from the applicant in relation to that memo, and there may be some scope for discussion in relation to these points, but I think at present there clearly is a dispute in relation to the impact and indeed the relevance of the indirect impact in relation to these settlements and forts. But I think at present that should certainly be a fourth bullet point in relation to that inquiry session.
Right, thank you. I've asked the applicant to provide me with an updated position statement, and that is in response to Dumfries and Galloway's objection. So in that, I would hope that I would get some kind of clarity. I think, Mr. Hardy, could you update me in terms of where you might be with that, or certainly within the next 7 days?
Yes, I mean, one of the issues in relation to D&G, I think it's the fifth ground of objection, was cultural heritage. That the underlying report to committee referred to a consultation response from the council's archaeologist, but the only consultation response available on the council's website, the portal, I think was 18th of April 2020. So that predates the FEI of May 2020, which addressed a number of the cultural heritage issues were raised. And there's a clarification response to the consultation response dated 15th of July of 2020. So, in short, we're not quite sure of what the council's current position is because it hasn't dealt with the FEI. So it might be helpful through Mr. Armstrong to ask for clarification from the council on its own position. Then, of course, we can respond and will do so.
And I think just to be precise on that, the additional information provided by the applicant didn't address Dumfries and Galloway's points. So it wasn't contained in that document. And that's why I referred to, I think, the letter of the 15th July from Headland Archaeology, which came back and responded.
The 15th of July 2020, is that the one, Mr. Armstrong?
Yes, that's right, which came back and responded to that. And obviously the council will in turn be addressing that. And I think there is perhaps some scope for discussion on that. But there clearly is an issue, and it is an issue in relation to the relevance of the indirect impacts, what the impacts are. And there is a dispute between the parties currently in relation to that. And I think that certainly for the time being should be one of the bullet points to be discussed. I think there is scope for discussion about perhaps narrowing down the extent of the dispute. But with respect, the 15th of July letter doesn't really it sets out a different opinion from that of the council's archaeologist. It's not addressing the point, it's just setting out a different opinion in relation to indirect impacts on prehistoric settlements and forts.
I think to a large extent then the position is common. What I was saying was there hadn't formally been a response to that FEI and that letter of July 2020, which I think is accepted. What is said is that there is a difference of view. If that then needs to be put down as a fourth bullet point, I don't think we can object to that. But in the meantime, there needs to be discussion between the applicant and the council, with the hope, Mr. Armstrong, of agreeing that narrowing the issues. I think we're at one.
Just on the consultation response that you've referred to, Mr. Armstrong, I don't appear to have a copy of that unless I'm having to dig through lots of documents I've already got. Where does that actually live?
It is on the website as a response. Ma'am, it is difficult to find because I don't think it's not part of the additional information. It is separate, and that's because of the timing of the Dumfries and Galloway response. But the letter is dated 15th July 2020, and there's an attached dealing with the various points, or attempting to address the various points in the council's memo. But it is on the website.
If it's helpful, we can just send a copy of that again, just to make sure that you've got it.
Yeah, with that date now, I should be able to find it. Any problems, then I will get in touch. Yeah,
yes,
if it's on our system, it'll be there. Just the way things have been categorised, I think, on our system. That's fine. So potentially there seems to be an agreement that we have a fourth bulletin point in there in dealing with these matters that are specific to Dumfries and Galloway, the indirect impacts on prehistoric settlements and forts. Right, Mr. Moffat, you've had your hand up. Do you want to come in?
Yeah, just with regard to headland archaeology, which is probably included in the bullet points, having looked at the archaeological report, it seems to be inadequate, to say the least. I know that land down there very well, and I know there's a number of sites which haven't even been noticed or recorded. Are your bullet points going to address that particularly? Because that's something which I would like to contribute to. I'll apologise if I don't understand the process of inquiry as well as others, because this is my first time. But how will the Borderlands Museum be included in that conversation at the inquiry with regard to archaeology in particular and the headland archaeological report?
But in a general context, if you're going to take part in that particular session, then you would submit if you're the key witness on behalf of the Borderlands Museum, etc., you would submit a recognition outlining what your particular concerns were and your case going into the inquiry. We act in a procedure where it's prior disclosure, so there's no surprises when you get to the inquiry. Everybody's aware of what matters people are going to raise and what evidence they're going to lead. Yeah. But you will have had sight of any inquiry statements that the other parties are looking to lead in advance of the inquiry. So you will understand the other parties' positions and be able to align yourself accordingly going into the inquiry.
Is it what I was hoping to do within a presentation is to make all of those points through aerial photography, etc. Will I be allowed to do so in the say a 2-hour session or an hour and a half session if I were to be allowed that?
But we've actually, it depends how, we've not talked about actual timescales for each of these individual elements. We're looking at 2 days in total for the cultural heritage inquiry sessions. Now, whether that's done virtually or in person, we'll talk about that as well. But there is potential there for a morning and afternoon, 4 sessions in total. Yeah, and as you raised this morning, there's the scope there to consider some kind of visual presentation. If we think that it needs, I need to understand that we don't stray into much more general wide issues. Yeah, as I touched on earlier on, that detract from really what I'm needing to understand and what I need to convey to Scottish ministers. Yeah. Until I see what evidence you're going to lead, it's very difficult for me to understand that.
Yeah, it is. So would you want to pop down independently, as we mentioned before, so I can show you some artefacts in the museum and give?
Yeah, that's a possibility. I wouldn't do any site, just to explain, I wouldn't do any site inspections unaccompanied. I would need another party there with me. So I wouldn't go and if I do anything unaccompanied, I'll come on to site inspections, I'll be doing that on my own, looking at visualizations. If I were to meet with any party involved in the inquiry, I'd need to have potentially the applicant there, representative. Yeah. So, but it's possible. It's possible that we could do that, and I want to give that some more thought.
Yeah, well, certainly very much welcome that. Okay. I mean, since over the past 2 years, since the Forside inquiry, we've been trying to meet with government ministers and we haven't been allowed. Those government ministers include Fiona Hislop, Fergus Ewan, Nicola Sturgeon, Mary Gogan, Jenny Gilruth, and we haven't been allowed to talk to them or express ourselves. In return to inquiries we've made and expressions, we've just really got fob-off letters that the cultural heritage is protected. So to date, as a private museum which has been operating for almost 40 years now, we haven't been allowed or been able to initiate or express our concerns for what's happening down here in terms of the destruction of cultural heritage.
Okay, yeah, I appreciate, I'm sorry to interrupt you, I appreciate where you're going with it, but I'm dealing with this particular case and I appreciate you've got wider concerns. They're not necessarily for me today.
This is absolutely related to the land you're talking about. What we've got down here, which is only, this region has never been archaeologically investigated. It's never been, its geology has never been investigated. What you've got central to the foreside is the Tivitat volcanic complex, which is a cluster.
Sorry, apologies. You're giving me evidence now, and that's not the purpose of this meeting.
Okay.
Can I please ask you not to get into that at this stage? This is a procedural meeting. Let's stick to procedures. And we've got an awful lot to cover today. I don't want to cut you short, and there will be opportunities, I can assure you, of putting this information across. This is not the forum to do that just now.
I understand. Okay. I mean, today I thought that we were just going to allocate time, and I'm not prepared with all this information. But what I'm hoping that you yourself will ensure that there's an allocation of time for us to be able to express everything we have unable and not been allowed to express to this this point in time.
Yes, I hear what you're saying, and I'll give you my assurances that I will look into that for you.
Okay, thank you.
Mr. Campbell, you've got your hand up. Is it in relation just to what we've been talking about?
Just for your notes, ma'am. Yes, it is. Just for your notes. Apropos of what I said earlier, the broad compass of the evidence is in section 4 of the 2019 objection lodged by the Forside Community Group. I won't take you through the substance of it.
Just run that past me again. So section 4, did you say?
I did, yes.
Section 4, yes.
Thank you, ma'am.
Yeah, it's a detailed bound document. I've got the full content of it. Section 4. Thank you.
Yeah, well, it's just a short passage, but it's just for your notes that it'll be easier for you to find it.
Right. So just tracking back, so I'm keeping track of where we are with all of this. We're concluding on cultural heritage inquiry session. So we've got the applicant, Scottish Borders Council, Dumfries and Galloway Historic Environment Scotland, obviously, who are going to take part in this, and Forside Community Group, and potentially Mr. Moffat as well, if we can facilitate some kind of input into that particular process in a visual format. Right, okay, and I think what I've suggested is that actually, although I indicated 1 day, I think we're going to need 2 days to cover all of those. Does that sound reasonable? Yes. Obviously, until evidence is led, I think 2 days is going to be needed, certainly, and 1 day is not going to be enough.
Yes.
Okay. The next thing I'm going to talk about is on to the inquiry session dealing with the seismic array. Now, before I do, I've noticed that we're nearly 2 hours into this, and I wonder if we should have a bit of a comfort break and just get a bit of refreshments and a break. It would, I don't know, 10, 15 minutes be okay for everybody?
Can I just raise something, ma'am? That is,
yes.
Obviously lots of detail to go. I've got a court hearing or a transport DFT thing at 2 o'clock. I'm not expecting this to go on beyond 3 hours. I don't know how much more you think we've got, but it feels to me as though there's another hour. So I wonder if we took 10 minutes now, whether you'd be prepared to go on until we finish, sort of even if that's 1:15, 1:30, just to facilitate that.
That's, to be honest, that's what I was thinking. I was going to have a quick 10-minute break now and then come back, and yeah, probably about an hour to finish up, I think, with everything else. We've got community issues to discuss. We've got the MOD, we've got conditions, yes. We've got site inspection, plus some other miscellaneous matters as well. And we need to talk about the timescales, yes. Which I think we're getting to slowly.
So on that basis, yes, 10 minutes, and that would be that'd be fun. Yeah. If
we could be back here at 12:05. Don't switch off your. Don't leave the call. Stay on the call. I think that's correct, Callum. Am I right?
Yes, if everybody could stay on the call and then turn their video and microphone off, that would be best.
Okay, and I'll see you back here at 12:05. Thank you. All right, welcome back, everybody. I'm just making sure everybody's back on the call. Quick scan down. Callum, is everyone back on?
Yeah, looks like they are to me.
I'm not seeing everyone at the moment. Everyone's moved around on the screen. That's going to confuse me. Okay, good. Yeah, I think we've probably got about an hour left, just looking at all the items that I need to get through, because we've discussed quite a lot of details so far. So hopefully a lot of that is kind of covered. I wanted to come on to the third inquiry session, which would be dealing with the MOD's concerns and the seismic array, which seems to be the main topic now that is of their concern. So it's the seismic variations on the operation and capability of Eskdale Muir seismic recording station. And I expect just the applicant and the MOD to take part in that session. Is that correct?
Yes.
And representing the MOD, Mr. Milne.
Yes. Yes, that's we're anticipating just the two parties.
And you indicated earlier that you felt that 4 days were necessary to deal with all the evidence, so we don't need to go back over that. I understand the background to this and the complexities of it and technicalities around it. And it may be that there are some areas where we might be able to reach agreement, but even 4 days is pushing it. I'll bear that in mind in the timetable when we come to look at it, because I think the week that we were looking at potentially for that session is the week beginning the 4th of July. That would give that potentially that whole week is the way I'm thinking about this, but I will come back to that when we talk about timescales. Mr. Campbell, you've got your hand up.
Thank you, ma'am. Improbable as it may sound, I'm asked by my energy policy witness to leave open the possibility of his brief participation in this session. Now, I can't say more than that at the moment because I don't have the evidence in front of me, but I would like to simply leave the possibility open. And of course, I'll inform you as soon as possible if there's to be a contribution. It's likely that it would be in writing and not oral, but there we are. I've passed the message on, so I hope you can accommodate that.
Okay, I've noted that down. Yeah, I would need to know as soon as possible what the issue was that was wanting to be raised. It's around policy rather than the details that we'll probably get into on the inquiry session.
Yes, I'm afraid I've just got this information only today, and I can't be more helpful at the moment.
Okay. But I do, at the moment, I'm anticipating just the applicant and the MOD takes part in any oral process to do with the inquiry. Okay. Fine, right. I'm going to move on to just talk about the other sessions very quickly, and then we'll talk about timescales. The next one that I have on my list is a hearing session dealing with community issues. Now, this is something we've done in the past where we've identified a session that really just picks up a lot of all the range of community issues that are flagged up, but those matters that I want to get more information on. And the ones that I've kind of honed in on in terms of the representations that I've read are really around the kind of economic impact of the proposal and tourism impacts, the socioeconomic and tourism impacts. So effects for visitor numbers, tourism, businesses. There's a number of businesses in the area who've submitted representations. The A7 tourist route in particular, that goes through the area. The visual effects on local recreational routes. So this is more about the I know that will be covered in landscape and visual, but this is more around the kind of community's use of local recreational routes as well as tourists, local historical viewpoints. And then into the economic benefits in terms of any net economic benefits and the local economic benefits that might be derived from the project itself. So I would expect those that are representing members of the community would be involved, and any representative bodies will be involved in this session. So I would expect the applicant, the community council that's represented here today, which is Upper Liddesdale and Hermitage Community Council. I would expect Fullside Community Group to be involved. Mr. Moffat, I'd put you down to be involved in this as well.
Yes, thank you.
Yeah. Mr. Hanrahan, Mr. Stephen Lucking, I think it is. Mr. Mundell, I've put you down to be involved in this session as well. Mr. McClymont, I think as well, I've got you down, and Ian and Alana MacDonald. So we've got quite a large body of people that build, and that's why I wondered why a hearing session might be the good format to run that. We'll talk about whether that will be in person or virtually. It's probably more likely to be in person if we're able to do so, because it would probably make more sense at a local venue. So just under those headings, is there anything that I've not mentioned, or anybody that I've not mentioned, that might want to be involved in that particular session? Mr. Mundell, first of all.
You're muted.
I'm muted now, sorry. There's never one of these without that happening to someone. I wondered about adding in community viability, if that was possible.
Sorry, can you just stop a second? I can hear quite a lot of voices in the background.
I've muted that now as well.
Okay, perfect. Just go again. Sorry.
I'm listening to parliamentary proceedings at the same time. It was about community viability under the kind of social aspect. Again, I think there's some crossover with previous inquiries, but I won't go into those. But I mean, again, there's some concern locally about some the impact on the viability of communities if people move away, or properties are unoccupied. And I'd just like the opportunity to to briefly touch upon that issue, and I think it's important.
Okay, so it's around general community viability. You mentioned people moving away. In what context? What do you?
I think it's a combination of properties becoming undesirable, okay, because of the impact on them, the loss of the tourism jobs, potentially, and again, I don't want to go into the sort of substance, but there's the suggestion that there may be some properties that have been subject to agreements, and I'll bring forward some evidence on that at the time.
Okay. There's the possibility, something around community viability, if I can understand a little bit about what you're saying. Just before I ask Mr. Armstrong to come in, Mr. Hardy, have you got any response to that as an additional item? You'd be involved in that session?
Yes, I do. Firstly, I mean, coming into the call, I'd thought that the community issues, actually, you've got a lot of the information in relation to the other disciplines, and it may well be that you could have taken a view that was dealt with in writing, but it seems, and in relation to what I'd already said about Mr. Mundell, that some form of hearing is probably going to be required. We think it should be virtual, and that week of session, so the planning, landscape and visual, so the Tuesday, Wednesday, Thursday, we think should be visual. It would be a shame if there was another day where we all had to trek up to the venue. We are proposing a physical session the following week, so we think it should be virtual. There are also some practical problems in terms of venue. Leaving that aside, there's a question about what you would require from the applicant to deal with these points, because you've got everything that we say that you require. What I mean, for countless wind farm inquiries elsewhere, what I've experienced sometimes has been a kind of an evening session or a dedicated session during the inquiry day, but it's typically being an evening session where it's a kind of a sort of hybrid. It isn't proper evidence, but it's where members of the community can come along and express what they want to say. There doesn't tend to be any form of cross-examination unless there's anything of a technical nature, but it's there more as a way of getting across feeling and in a non-qualified way, important evidence from lay persons. So I just want to understand that from you, Mum, what your expectation is. Is it in that this is an opportunity for the members of the community, and I would include Mr. Mandel and Mr. Moffat in that, to have their say, absolutely right, but it's in that context rather than some form of evidence where you would be expecting more structure and cross-examination and indeed evidence from the applicant on those topics?
Yeah, I mean, the fact that I've tabled it as a community issues session and a hearing session is, I haven't ran one of these types of sessions before. The evidence has tend to be very specific, and I've honed in on that in a hearing session. But this seems to cover quite a broad range of topics. And as Mr. Mundell alluded to there, around community viability generally, is quite a wide topic, and the socioeconomic issues. There's quite a lot of information coming through the representations and by local businesses, and that I would like to explore. And it's possible when we have had evening sessions before. I'm keen for this to be in person for the very reason that it's held locally and that local people could, who have indicated they want to be involved, which is quite a few participants actually, could actually come along and speak in a hearing session. Now, a hearing session is structured by me. There'll be a list of topics and questions that I will want to ask. People will get the opportunity each individually to respond. There's no cross-examination. It's more of a discussion and fact-finding exercise on my behalf. So that was the intention. It potentially could be evening session. I was hoping, in fact, the reason why I put it as a in-person session, I was hoping that we could run it in the first week.
Can I just say, I wasn't suggesting it was an evening session. What I was saying, in previous inquiries,
yes,
it has been seen as an evening session for two reasons. One, to enable people who are working during the day to take part. But secondly, because it's seen as being slightly set apart from the formal evidence in the inquiry. It's seen as an opportunity for non-technical evidence to be given. Absolutely important to do that. So I was just trying to understand from you, it will happen during the day, but what is the status of that? Is that formal evidence, or are they taken simply as lay party representations? And what's the expectation from the applicant? Because at the moment we are not proposing to do papers on economic impacts of impact on tourism. Mr. Mandel, if he's going to say what he said at Sanka, will be making a point about clearance and modern and turbine operators coming in and moving people on. We're not going to present evidence on that unless you specifically want us to.
Yeah, as I said, I think it will be an opportunity for these other parties to have their say, and with you to be there to respond accordingly and for me to direct any questions that I need to direct to you. It's a little bit of an unknown at the moment because the raft of things that have been raised are quite broad. I've tried to hone the topics down, and as Mr. Mandel suggested, perhaps another topic needs to be in there as well. Can I just ask other parties to come in? Mr. Hanron, and you had your hand up first of all. Can I just ask you to speak first?
Yes, thank you. I strongly feel that the representation should be in person. I think the ideal venue would be the Baclure Centre in Langham. And I would like to see representatives of the Tarras Valley Nature Reserve also in attendance, because that's what we've renamed the land that we've bought on behalf of the community. Because there are a lot of issues regarding the nature reserve and what our plans are for that parcel of land. So what was the party you mentioned there? The nature reserve. The Tarras Valley Nature Reserve. Yeah.
Tarras Valley. Have they made representations to this particular case? Do you know directly?
I don't know whether they have with via the Foreside Community Group. I don't know. but certainly we've got a very extensive business plan and a peatland restoration programme, and all these issues need to be discussed and presented to you, Mum.
They need to be. I need to be aware of these issues, but the level of detail that I need to be made aware of, and again, I come back to the point. The understanding the impact of this development in relation to those particular concerns is what I need to understand, rather than the generality of a lot of the wider context. I need to hone these matters down for practical reasons, for efficiency reasons, and so that we can get through the inquiry. There'll be lots and lots of things that people want to highlight to me, I'm absolutely sure, which is why I want to run a community session. But it's getting through all the evidence in that particular session. I would need to understand a little bit more, I think, about what matters you would want to cover. Sorry, did you want to just come in quickly then, Mr. Harvey, before I do?
Yes, just to say, I mean, obvious concern is that this then isn't, I mean, it's a difficult balance for you to strike, that this doesn't then become a stalking horse, which it has done, I have to say, and this is a real concern in many wind farm inquiries, and it's a problem. It becomes a stalking horse for all sorts of potential tripwires for decision making, which aren't then dealt with in a formal evidential way. So you've got no ability, or the applicant's got no visibility on what's going to be said. You can't stop people from turning up, and they might have wafts, they might have rafts of paper, and buried in those papers might be points which could lead somewhere. So there's a danger in not knowing who's going to be involved and what's going to be said. And I think if we are going to pursue, and it sounds like we are, a community session, that we would want advance notice of who's going to be speaking, what they're going to say, and they ought to be brought within the procedural timetable for advance disclosure of their cases, because otherwise there's a real disadvantage to the applicant and real prejudice. So I think the flip side of rights and responsibilities, if people can come along and say what they want, the applicant needs to know what they're going to say, and we need the opportunity to be able to respond properly.
I think for me to establish a hearing session, which is, I want to run this as a hearing session, so it is structured in the way that it's run. It's not a free-for-all. It would also have an agenda that would be set by me in advance. In order to do that, you're quite right, Mr. Hardy, I would need to see what and have an idea of what matters people want to raise, so that I could keep people on track and I could hear and go through all of that evidence. So yes, I would intend to operate in the normal ways that we would normally do through a procedure, but we would call it a community hearing session. So that because of the topics that it's covering, because of the wider range of things that it's covering, if that provides some kind of comfort to you in terms of understanding, but also some comfort to the communities as well, that I want to touch on all of these issues that have been raised, and to separate them out as individual topics is too difficult, because they all interrelate, and it's important that I hear them perhaps in one session. Now, there's a number of hands up, and I just want to go to Mr. Campbell, I think was next. Could you, yes, your hand was up.
Thank you. As you know, my clients are called the Forside Community Group, and the ambition of the community group is to marshal as much as it can the evidence of members of the community on the topics that concern them. Mr. Hardy has attempted to classify this evidence as some sort of B-grade evidence, which he says is not technical or not professional or not whatever. But it's not. It's evidence, just the same as the evidence of technical professionals. So when I bring forward the evidence of the community group, and I'm sorry, ma'am, if I'm boring you, but just bear with me for a second, if you would. When you bring forward the community group's evidence, it has to be in a form which is understood to fit with the inquiry processes. In other words, there has to be a report, there has to be a hearing statement, which will put within a frame the evidence that these people want to give. Whether you accept or reject it later, that's up to you. But it needs to be notified in advance to the applicant and the councils. It needs to be understood, set out clearly, and not simply waffling from the public benches about dissatisfaction with the wind industry or renewables or whatever it is. So Mr. Hardy really is preaching to the converted. It's proper evidence, though. It's not simply somebody having a go for the sake of it.
I'm very grateful, and I agree. If it's in that format, then that's exactly what it is. I think it's just like Mr. Campbell, very experienced in doing this, that you do find that there are submissions which don't fall into that category, which then cause problems. But I'm very pleased to hear what he's had to say.
Mr. Armstrong.
Ma'am, just three brief points. First of all, it's the intention that a representative of the council would attend this session, but it's not intended that they would necessarily participate, and it would more be a watching brief, or if there's any point of clarification required. Secondly, just in relation to the discussion about in-person or virtual, again, it's the council's position that they would like all the sessions to be in person if possible, and if the regulations allow that. Thirdly, somebody mentioned the Buccleuch Centre, or sorry, it was mentioned the Buccleuch Centre as a venue. We do have details of availability of some of the I think there's 3 potential venues in that would be suitable for, or potentially suitable for, an in-person inquiry, but I think that's probably going to be dealt with later on in this discussion.
Okay, thank you for highlighting that. Mr. Moffat, you had your hand up.
Hi, I think it's really important that there's a forum for people to speak without sort of cross-examination. You will live in a rural population here, and once you talk to people, you'll realise there's many people who have been under years of stress now and aren't necessarily able to articulate themselves in a situation of cross-examination. And I think it's really important. I think you'll find a lot of valuable information comes out from talking to people. So I think what you're suggesting is really important, to have a forum where the real people who live here can talk and express themselves without the pressures which they will otherwise be subject to.
Are there any difficulties you think, Mr. Moffat, speaking, on behalf of some of the community representatives, a daytime or an evening session? I was anticipating it be during the day, but obviously we can be flexible in when we might run the session. I'm
not sure about that. I really don't. You'll have to make that decision. Obviously, people are working during the day, but sometimes in the evening, people are tired out, and evening sessions are good. But I'll leave you know better than me for that. But I think also the context of the community which you're coming into now is a community which has been affected for a generation by losing a lot of its assets in terms of hotels and recreation centres. And I think we have to, when it comes to economics, we have to evaluate the possibilities of the region and what its assets can achieve, which will be incredible. And I think to put that in the context of what's going on in terms of wind farms.
Okay, can I just stop you there, Mr. Moffat? You're giving me various evidence again, and you'll have the opportunity, absolutely, at the session to do this. And we are going to have a session dealing with this, and it's my intention that you will have plenty of opportunity to put those views forward. So, yeah, if we could not go into any detail at this stage. Mr. Armstrong, you've got your hand up.
Apologies again, I've not put it down from the last time.
Right, just if there's some further thing you wanted to say. Is anybody else got the hands up? So the intention is to have a community session. My preference is to have that in person. I'll come on to talk about, my preference as to why certain things are in person or virtual. I understand from Dumfries and Galloway's suggestion there that all of it should be in person. This all very depends on the regulations going forward, but also the way that DPA is operating its business at this time as well. And I'll talk a little bit about that in a while. So moving on to the next session, which would be dealing with draft conditions and any planning obligations. Now, just a second. So this is not a fait accompli. This would be something that we automatically would do as part of considering any application. It doesn't mean I've made my mind up. We need to explore any potential conditions should the minister want to recommend, as such as the minister want to actually approve the development. So I need to put forward some suggested conditions. As far as possible, what I would try to do is get people talking to one another, particularly the main parties, so the two councils. because they would be involved in some ways, and also the applicant in suggesting conditions as well. So there's normally, the way that we do it is normally through a process of backwards and forwards and liaising between the parties. Now, I've outlined in my agenda the expectations for the applicant and the councils in submission of draft planning conditions, and heads of terms if necessary. Heads of terms is what you would put together for drafting any planning obligation that might be needed as part of the development. So I expect the two councils to take part, so the Minister would be aware of their positions on any conditions that are in dispute. Would a hearing session work? I've done hearing sessions on conditions before, and it tends to be something where you need to kind of talk around the topics and then move on to the next and move condition by condition. And I've put a day as being an indicated for that, which is ordinarily long enough to deal with a condition session. The persons that I've got involved, I've got a question mark around Forside Community Group because of, I think, they've given an indication that they might be interested. Mr. Campbell, could you come in there, please?
Certainly, I would be keen to see the draft conditions. I would tinker with them only with diffidence, but there are always issues which concern the community and conditions, and I would like to see them before they're finalised. I would rely on the applicant, as I know I can, to send me. I've had dialogue with Mr. Keith Campbell before on this matter, to send me the floating draft as it evolves, and of course I'll make a contribution if necessary.
Would you intend to take part in the hearing session itself or not?
I think I would intend to be present, yes.
I think if it gives some comfort, then Mr. Campbell, Mr. Armstrong, myself worked through the conditions at, looks like my broadband may have just frozen.
Yes.
We worked through the conditions at Sankatu, so very recently. So there is a very good base. There will be some obviously some site-specific amendment, but in the main, a very thorough discussion was held on that. And I think it's a very good place to start for this set of conditions. So I'd expect us to get a very long way before we actually need to get to the procedure. And there is no legal obligation, so there won't be a Section 75 discussion.
None at all. Okay.
Thank you.
Right, that concludes all the specific sessions and the topics. What I'd now like to talk about, I'll come on to site inspection in a while, is the actual dates for the sessions. Now, the revised agenda that I put out. Sorry, yes,
I beg your pardon for interrupting, but you haven't discussed, at least I don't think you've discussed, ecology, hydrology, noise, telecoms, carbon calculator, or residential visual amenity, which is the bottom of your Annex A.
Yes, that's written.
What I'd like to say is that the Forside Community Group would like to contribute a written submission on the question of bats.
Could I come back to you? Sorry, Mr. Campbell, could I come back to you on written submission? I just want to stick with the oral processes first, and then I'll go on to written submissions, if you don't mind.
Very well, then. Can I just suggest to you that residential visual amenity, which is the fourth last on your list, should be pushed up into the landscape and visual session so that all those topics are taken together. We've heard this morning that Mr. James Welsh, who is to contribute the landscape and visual impact evidence, has also been able to advise Mr. Hardy on my earlier question about the RVAA. And it seems to me, for what that may be worth, that that is a topic which sits very nicely with landscape and visual amenity.
So you're suggesting that the inquiry session dealing with landscape and visual matters, I should add a bullet point to that dealing with residential and visual amenity assessments?
That's correct.
Okay. I'm also going to have a written submission on that as well, in relation to another separate matter, so it can be covered in both. Are there any objections to that? I'll ask Mr. Hardy from the applicant's
Yes. Well, there's been no, there are no issues that have been raised in relation to that. We don't think it's necessary. You've got everything. You do have this question that's been raised this morning about the additional properties that you've got to determine. But other than that, it's not something that needs to detain us in the inquiry. Written procedure will do. And obviously you'll go and see things on site. I mean, ultimately, that is armed with the information, you'll go and form a view.
Mm. I'd like to give that some more consideration. And I haven't devised what my further written submission in detail will be on that particular matter at the moment. It's just, I know it's something I want to explore, and it may be that I can cover it fully and get everything I need in written submissions. So I will just leave that with a question mark at this stage. Right, just looking at timescales before I'll cover further written submissions after we've talked about this, and availability is varied. So I've done my best to see if I can come up with something. We're looking at a 3-week inquiry now, and there was a suggestion, I think, from I think it was the applicant, to bring it forward a week. We're starting on the 21st of June. That's not going to work for myself, but also I think for Historic Environments Scotland particularly. So I wonder if we should stick with the 27th of June, that week, as the start of the inquiry. We don't normally sit on the Monday, but I had tabled some Monday as being a day that we could sit. It's not impossible to hold sessions on Mondays, but I think it's just with people travelling up and down and getting set up for the inquiry, we tend to not have a Monday. So if we can avoid a Monday, I will try to do so. So my suggestion at this stage, and I'll ask you individually what you think of all of this, is to kick off the inquiry on the Tuesday, the 28th of June. And that would cover a policy hearing session. I think we've talked about that being a hearing session at this stage. And then the 29th and the 30th of June would be the landscape and visual inquiry sessions. And then the Friday of that week, the 1st of July, I'm proposing that we hold the community hearing session. And then we move into the following week. I'll just go through all of these and I'll ask you afterwards. We would cover all of the MOD's concerns in that following week. I understand the MOD can make that week, and I understand the applicant can make that week, the week beginning the 4th. So it would start on the Tuesday, on the 5th of July. So it would give it the full 4 days if required through to the end of the week. And I'd hope that we would get through all, if for some reason, and I know you've said that you think 4 days is tight, if for some reason that we're needing to start that on the Monday, we could always bring that forward early in the Monday if it seems and looks like a lot of the evidence potentially, or even starting halfway through the day. But I'm going to propose that we start on the Tuesday and we finish on the Friday. And then
that suits the MOD. Sorry, ma'am. Sorry interrupting. I think it makes sense to try and keep the Monday in reserve. Should we, the parties become increasingly concerned as we approach inquiry about 4 days being sufficient. So yeah, we'll keep the Monday in reserve.
Yeah. Okay. Then we have a period of hiatus where, unfortunately, people are away. There's no availability for all sorts of different people aren't available in that particular time frame. And I'm jumping on then to week beginning the 8th of August for the final week of the inquiry. Now, presumably, this is potentially going to work for people, but you can tell me if it isn't. Not sitting on the Monday, but starting on Tuesday the 9th with the Cultural Heritage inquiry session, and continuing on into the Wednesday the 10th. And then on Thursday the 11th of August to have the conditions hearing. And then on Friday the 12th of August to have an accompanied site inspection. Now, yes. I'll go through each party just to see how that works for everybody, starting with the applicant. Mr. Hardy, does that...
In short, that's exactly where we'd got to. I mean, there's been a lot of toing and froing. A couple of points. One, I think it's really important to keep Mondays free for a number of reasons. There's travel, family commitments at the weekend. If it's a Monday, you have to lose your Sunday afternoon, and I don't think that's right. Second, for anybody. Secondly, I think it's important for conferences for the week that's coming up. So I think that Monday ought to be kept free. Happy with the rest of that. My view I know you're just looking at dates, but I'll just take this opportunity. My view is in relation to virtual or physical. The first week can be virtual and ought to be virtual. There's absolutely no reason why not. The second week, MOD We agree with this. They want it in person. It is very technical. That might be better suited to physical inquiry. And then the last week can also be virtual cultural heritage and conditions. So yes to the timetable, virtual first week, physical second week, virtual third week.
Okay, thank you. I've got your views on that. Can I now just take it to the council? So can I start with Scottish Borders Council, please?
Thank you, ma'am. No, there's no difficulty from the Scottish Borders Council's perspective with any of that. All the suggested dates work for us. And ma'am's hands as to whether hearing should be virtual or in person. No real objections to what Mr. Hardy's proposing.
So, okay, just on that, so you're agreeable that the first week dealing with policy, landscape, visual and the community could potentially be virtual as well, and the dates also work for you in terms of a virtual session dealing with cultural heritage as well from Scottish Borders point of view?
Yeah, that's the case, ma'am.
Mr. Armstrong, Dumfries and Galloway Council.
Ma'am, these times and dates all work for the council, and we're happy with that. As far as I've already said, that our preference is very much for it to be an inquiry session for all of the inquiry and hearing sessions.
Sorry, just clarify which sessions did you want as inquiry that are not indicated as inquiry?
So no, for actual, whether it's virtual or in person. Our preference is that they should all be in person, both the inquiry and the hearing sessions.
Okay. Right, so I heard you wrong there. All in person. Are there any particular reasons why you think virtual session can't happen with some of them? Well,
Ma'am, certainly in past experience, there is an issue with in relation to people participating online, particularly in this part of the Scotland, where broadband is not as strong as in the sort of city centres, and certainly there have been issues in other inquiries, and the council considers it's desirable that obviously it's an inquiry in public, that people should be able to see what's going on, and the best way to do that is through having it in person.
Okay, all right, I've noted that. I'm going to just go around. Sorry, Mr. Hardy, did you want to say something?
Just very quickly, I actually disagree with that. My view of the virtual inquiries is that inclusivity, the ability to take part is actually increased. And I think that people can do that. Sometimes they can listen in for sessions. They may be doing other things. They maybe have headphones and so on. And there's been lots of experience of that. So I think if the fear is of people taking part, then actually it's better. And the evidence that I've seen from certainly south of the border from Pins is that inclusivity is increased through virtual formats.
Okay, I'm just going to go around. Mr. Moffat, could I come back to you in a moment? I'm going to ask you to comment once I've been through some of the other parties. I don't want to lose my train of thought here. I'm going to go through everybody. So the next person I'm going to go to now is Mr. Milne. And could you speak on behalf of the MOD and Historic Environment Scotland, please?
Thank you, ma'am. These dates are all fine. The 4th, 5th to the 8th for the MOD, and obviously we've discussed that being in person. Cultural Heritage, Historic Environment Scotland are fine for the 9th and the 10th, and are happy to leave it in your hands as to your preference for whether that session takes place virtually or in person. The only other point, and you can stop me short on this if I'm getting ahead of the agenda, but the dates of the 9th and the 10th work for Historic Environment Scotland, provided that the evidence for that session is lodged recognitions 2 weeks before that session, rather than 2 weeks before the commencement of the inquiry on the 27th June. There's been a fair bit of rejigging of diaries and looking at holiday commitments over the course of June, July, and that's how we're able to make that work in terms of witnesses being available actually to consider reports and produce recognitions. So that may create issues for others, and we can come back to that if I'm interrupting
We're happy,
in terms
Mr.
of
Milne. We're
availability.
actually happy with that, ma'am. If that's helpful, 2 weeks before the individual session is fine by us.
I can build that into the timetable. I think because we're having to assist the inquiry for a couple of weeks in July anyway, and obviously delay the session on cultural heritage, I think it would be unreasonable of me to expect all recognitions to be in by the 27th, 2 weeks prior to the 27th of June, for a session that's not happening until August. So I'm quite happy to do that. The rest of the week is conditions. So we'll certainly do it for that. But for all the other sessions, because they're happening in July, we'll bring them, the recognition need to be in 2 weeks before the start of the inquiry. Okay.
Yeah, and sorry, ma'am. Also, in terms of lodging inquiry reports, just for avoidance of any doubt, same timescale, 4 weeks before the actual session. Thank you.
Yeah, happy to build that into the overall time. What I'm going to do, in my note of the meeting, I'm actually going to put the dates in as indicated. So I've given the rough indication of 12 weeks before, or 2 weeks before, 8 weeks before for various things. I will actually put the dates in so that they hopefully, and I have scribbled them down actually. So we'll just I'll run them past you when we get to the documents discussion. Right, so that's some of the key parties there. Now I want to just move on to the other interested parties. So I have a number of people here. Can I just ask Mr. Colby from the Community Council? So the community session, which will be on the 1st of July.
Yes, ma'am. That is fine by us. You have it, as I understand it, being in the first week that you are proposing that this should be virtual rather than in person. But because of the broadband issues in this area, we think that this session should be in person.
Okay. Thank you. Moving now down on to Mr. Campbell on behalf of Foresight Community Group.
Yes, ma'am. Thank you. All the dates are suitable for us. I agree with what Mr. Colby has just said.
Preference for in person. Yep. Now, Mr. Moffat.
I think those dates are all right. If something's in person, I take it it's also recorded at the same time. Yeah.
Whether it's virtual or in person, yes, they're both recorded. Yeah.
Right. The only thing I would think about is how would I demonstrate, imagery on virtually. That's not something I've experienced.
Yeah, I was thinking about this. I had a little think about this in the break actually, and just had a quick chat with the technicians as well. And we were wondering whether there might be something that you could submit as part of your inquiry evidence statement that's a video or footage that you want to actually show, so that I can have sight of it in advance. Then rather than talk to something that could take quite a lot of time. Mm-hmm. That we've then got to record, and we've got to make it work as well in a virtual format. Is it possible that you could produce something that you could submit to me in advance that I could then look at and read in advance of the actual sessions, and it would be obviously distributed amongst the parties involved as well?
Yeah, to some extent I might be able to summarise it. I mean, when I've done slideshows in the past, usually you just talk and make points. If you've got an image, you'll point out paths or features on the landscape, or etc. etc. I mean, it might be difficult to produce something in its entirety, to be honest. I'll give it a go.
If it's helpful, on other inquiries I've been doing virtually, screen share, you can run, providing the authority is given, you can run PowerPoint or video or whatever it is. I've just done one where that was done, and in fact, virtually, it's very easy to do.
Is it?
I noticed that the last inquiry that we did in Scotland was actually on Cisco's WebEx. So I noticed this is on Microsoft Teams, and I don't know whether or not Teams is going to be the platform for the inquiry. If it is, it's very easy to have. It's easier to do screen share on Teams.
Yeah. Okay. Yeah. Well, that might work because, as I say, it's a sort of flexible thing where there might be a question you want to be asked about a landscape feature or whatever. If that's a possibility to run a slideshow through Microsoft Teams, that would probably be the way to go.
Okay, we'll bear that in mind. I'll have a think about how we might work that practically.
Right. Okay, thank you.
Okay. Now I've got Mr. Hanrahan Yes, you're on the screen. In terms of availability for the community hearing session. Your audio is not switched on. Can't hear you, Mr. Hanlon.
Using my phone. I'm absolutely fine with the dates, and I would reiterate my wish for this meeting to be done in person. There are a lot of people who live in the area who don't have access to a smartphone or even a computer. And I know that they all want to make their views known during this inquiry. So I think it's very important that the meeting is done in person.
Okay, thank you. Thank you. And finally on the call today is Mr. McClymont. I think he's still with us. Yes.
Can you hear me, my lady?
Yes, we can.
Thank you. From previous public inquiry in Ayr many years ago, I represented in person, so my preference would be in person. However, maybe the other facility can also be available for those wishing to make representations. Today, I don't have a computer, but I'm using a mobile phone, and although it's working well, my preference to make a representation would be in person, please. Thank you, milady.
Okay, thank you. Right. On the whole matter of virtual or in person, and I had some initial thoughts about this, and I'll maybe just talk a little bit about what's happening in the DPA generally. So as we come out of the pandemic, we've learnt a lot of lessons in running quite a lot of sessions virtually, sessions just like this. All our pre-examination meetings now are done virtually, where it works and where people can get connected. And I know personally, I've ran some individual sessions, landscape and visual sessions where there's a few parties involved. I've done that virtually as well as in person. So there's all sorts of ways in which we can do it. We are introducing a gradual resumption of in-person inquiries, and our latest guidance note, has, I think, produced in February, indicates that where it's appropriate to do so and where it's considered safe to do so. But we want to continue with some virtually run events where we think we can make real efficiencies, where it's more sustainable, not to draw people from lots of different locations, where it makes practical sense, where the people can get broadband connections and get through to the core is very, very important. And generally, we get reasonable connections, but there are areas where we can't do that all the time. Given that this is running over 3 weeks, I think the scope here to have a bit of a hybrid approach, if that's appropriate. And that's what I'd initially set out in my agenda. So it would involve some inquiry sessions taking place in person, some hearing sessions in person, and the rest would be done virtually. Where there's unlikely to be any public involvement, I wondered if those could be held virtually. They probably make more sense, and given what's been said today by a few people involved from the local community, it sounds like in person is preferable and would work better for them. So I hear what's been said today, but I wonder if there's a suggestion that this hearing session, the policy hearing session in the first week and the landscape and visual inquiry sessions, the applicant suggested that these could all be held virtually. I've done a landscape and visual inquiry where there were just a few parties involved, and I've done that virtually. I do wonder about the possibility of being able to run this virtually where you've got 2 councils plus potentially some other parties involved. And that's the one I probably want to explore the most. If we are, my view on the community session is that should be held in person, and that would be on the Friday of that week. If we have a venue for the week anyway, and if the restrictions are lifted by that stage and we're not contained to social distancing at that point, is there any difficulty with running the whole of the first week in person? Mr. Hardy, I think your suggestion was that be virtually, because I'll come to you first.
Yeah, very strong preference, I think, for these to be dealt with virtually. And I've dealt with huge inquiries which are being online. There's no difficulty at all. in having the fact that, you know, you've got a couple of councils. That doesn't make any difference with respect. They can be run, my view, they're more efficient. They are, they're time efficient. People know what's got to be done. They are more focused, and there are there's cost effectiveness in terms of document production. We'll have to come on to that, because if you start to veer into physical or even hybrid, you just have to produce everything 10 times over in paper. There is a massive cost to that, and that's all parties will bear that. It's not that's not for free. There's also a big carbon footprint which is not required, and I think in terms of inclusion, as I say, that the virtual format actually enables more people to get involved than not. So it's a really quite strong preference for these to be dealt with in a virtual way. I have to say, another way of doing the other inquiries, they run on a hybrid basis. The hybrid basis is not what you've described as hybrid, but actually it's hybrid. You can be there in person or not. And if this was virtual, there may be a call which is made by the applicant to save a carbon footprint, cost, documents of us not attending the community session in person, but to listen in and just have that on Teams. And therefore we would not come for that first week at all. So it's a strong preference. I don't see any downsides. I do see upsides.
Okay, I hear what you're saying. Right. Yeah, I mean, I think we need to be clear about what we mean by hybrid and kind of blended sessions. Yeah, blended sessions where you've got some people sitting in an office who are in a meeting format, but then there's other people connecting in virtually as well. So there's different terms.
I'm doing an inquiry in Newcastle next week. Some of the witnesses are in Brighton. Some of them are going to be sitting in a room in Newcastle, and that works perfectly well. So I think if it could be virtual, to save us having to come up at all on that Friday, then we would probably listen in, because I'm not expecting formal cross-examination in the community issues session anyway. So my preference remains virtual for the first week, physical in the second week, MOD, virtual in the third.
The key parties that are keen on in person is Dumfries and Galloway Council and also Forside Community Group. I'm talking about the policy in the landscape and visual sessions here. Can I hear from Mr. Armstrong just on terms of what Mr. Hardy said there?
Yes, I mean, Ma'am, you've already got my submission on this, but just to come back on one or 2 points, I'm surprised at Mr. Hardy's comments about having no difficulties, because in the last inquiry that I did with Mr. Hardy, there were a number of occasions where, in particular, his broadband seemed to freeze and we lost him. Clearly, the more parties involved, it just needs one party to not be on broadband or something to happen, and the inquiry's got to come to a stop. So I think that there are dangers that if we have the number of people involved, particularly in the landscape and visual inquiry, there may be sort of continual stops due to people's broadband breaking. And it's certainly occurred a couple of times in relation to, in fact, more than a couple of times in relation to the last inquiry I did with Mr. Hardy. I don't think Mr. Hardy's point about the documents is really a relevant point, because you can certainly have an in-person inquiry and have electronic documents. I don't see why, just because we're in person, that we need to have all paper documents. So I don't think that's a valid point. And so I don't really think that any of the points that Mr. Hardy raised would justify us not having an inquiry session for particularly landscape and visual and planning and policy sessions, and indeed the cultural heritage ones as well.
Certainly, it seems that there shouldn't there must be a backup plan if things crash. Like, we can't allow that on an issue as important as this, I would have thought.
Yeah, I mean, we rely on the technology so much. We do testing before we get into sessions. I mean, sessions have had to be postponed occasionally when connections are lost, and that's time lost and having to rearrange things. But generally,
I was going to Sorry, I was going to say, I mean, Mr. Armstrong is completely exaggerating about the impact. It was at work, which is a commercial, obviously in our offices. There actually has been some Wi-Fi strengthening since then. There was no loss of time. It was a couple of minutes, and we finished on time. So I don't want it to be thought that that was somehow, problematic for the Sanctuary inquiry, because it certainly wasn't. And as I say, the Wi-Fi has been strengthened, and it wouldn't happen. So.
I'm probably not going to get to the bottom of this. There are views on either side. I think I will go away and think about and talk this in the office about how we might want to run this. Are there any other views on virtual or in person that I've not already heard so far? And Mr. Campbell, you wanted to come in.
I'd just like you to record me as being in complete agreement with my learned friend, Mr. Armstrong.
Yes. Yep. A preference for certainly in-person sessions. Yep. Just Mr. Milne, I just want to check with you in relation to HES's Historic Environment Scotland, that you've got no preference for in-person or virtual. So we could run that. We potentially could run those sessions virtually, those 2 days.
Insofar as we're concerned, yes, we had good experience about a couple of months ago in an inquiry for a development which each ES objected to in Argyll and Button, and that worked fine virtually, dealing with complex cultural heritage matters.
Okay. Right. Quite a bit of things for me to think about. It's really the first week that's the key one, I think. Mr. Hammerton, you've got your hand up. Did you want to come in?
Yeah, I just wanted to say also that there are parts of this community that don't even have a mobile phone reception as well as broadband, so it just wouldn't work virtually.
And that's why I want to avoid sessions where the community are really intrinsic to the session, that we would have an in-person. So my view is that we would have the community session would be the community representatives will be there in person. I'll be there in person, but I think the suggestion is from the applicant's point of view is the applicant would dial into that. We would have a kind of hybrid session where the applicant would be available as part of the hearing session, but remote connection. Okay. And that's possible. That's possible to do that if that's the preference. So that's one example. I need to have a think about the earlier sessions of that week. Okay, so it looks like we've got a timetable that works, and I'm happy that we're able to do that today. So that's really good news. I'll put that down in detail in the notes of the meeting.
Yep.
Just before I move off the virtual and in-person, just in terms of all sessions, we tend to start for an in-person inquiry or hearing session. We tend to start around 10 a.m. on the first day, and then thereafter we start around 9:30. We take a break in the morning. We just take breaks where it's appropriate and a lunch break at appropriate moments, and we aim to finish around 4:30, 5 o'clock. When you're doing a virtual session, we tend to keep the sessions, we start at 10 o'clock, we tend to keep the sessions at two-hour blocks, really, because of the length of time that people are having to stare at screens. So you don't tend to cover as much, potentially, in a virtual session, you in terms of the amount of time that you allocate to the particular area as well. So that's something that I'll bear in mind in terms of how much information we need to get through. And obviously, parties just be aware that we may have to go down a completely virtual event if the pandemic continues and if something it changes in terms of government guidance in terms of what the DPA is required to do. So just bear that in mind. Okay, I'm going to move on to Mr. Moffat. You've got your hand up. Is there anything you wanted to say, or have you left your hand up?
Oh, I beg your pardon. No, it's
okay.
left up. Sorry about that.
That's fine. Right, just moving on to written submissions, and there are a number of items which I flagged up that, well, before I do, there's a number of areas where I haven't indicated any further procedure, and that is around ornithology, transport and forestry. Having been through some of the representations and got a feel for what some of the concerns are and also what information I need, there wasn't anything that jumped out to me that I felt needed to be covered. Now, Mr. Campbell, do you want to come in there?
Just quickly, there is a project called the South of Scotland Golden Eagle Project, run by the Southern Uplands Partnership, and I'm instructed that they wish to make a written submission to you on golden eagle habitat.
Yeah, I think I'd pick this up in one of the submissions. Now,
so that would mean That would mean moving ornithology, sorry, one block to the right, I think, if you were to allow that. And clearly the applicant would want to respond to it.
Yeah, I suppose if I was going, what I was hoping to do on the further written submissions, because I haven't set out in detail the matters that I'm actually looking, I was going to do it as a separate procedure notice, just so I can outline what information I'm looking for under the various topic headings. I would need to understand what information it was that I was seeking there and for what purpose.
Of course.
So a little bit of an unknown.
Can't help you at the moment. Can't help you at the moment, but as soon as I can, I'll let you know.
So this is a project that's been going on for some time, and a project that is obviously there is an assessment done in the report that's been submitted as part of the EIA. Presumably it touches on this particular project, does it, Mr. Hardy?
Yes.
Is there any update that you might be able to provide to me with regard to that project and the way the way that you've considered that project, and then I can ask the other parties to come back on that?
I'll have to take instructions, I'm afraid, on that.
Okay, I'll note it down and to have a look and potentially add that to the further written submissions.
Thank
you. Mr. Moffat, you've got your hand up.
Yeah, you just mentioned forestry there and golden eagles. I don't know if like the geese, the barnacle geese, are included at all as a discussion. We've got flight paths into the Castleweary sanctuary as a protected species. I don't know if that's something you're going to discuss, but it should be included. Also, with regard to forestry, I don't know if you intend to talk about that as well, but the future Scottish Government policy and existing policy is to keyhole turbines within forestry. So landscapes like this are getting, forestry, blanket commercial forestry, as well as the turbines. I would have thought that would be something you want to discuss as well, because the forestry is impacting very heavily already on all the valleys around here, which have, archaeology and, cultural heritage, which isn't acknowledged properly or at all.
Okay. You're straying into other matters here, and some of this may well come up in terms of the cultural heritage session, but these are just to explain how the inquiry session works, in that we don't cover every topic, and it doesn't mean because I haven't listed a topic as requiring further written submissions that it's something that I necessarily agree with, or that it's all, it's just that I can appreciate and understand it, and I don't need any additional information on that particular matter. So I'm trying to hone in on those matters that, there's so many topics covering a whole range of matters, which I've got the full environmental assessment report that's been submitted to me that covers these range of topics, and I've got representations. It's only really those matters that I feel I need more information on that I'm having additional written submissions on, which are the ones that I flagged up there. So I wouldn't intend to go into forestry in any detailed sense, and I don't intend to go into transport. The matter that's been raised by Mr. Campbell about the South of Scotland Golden Eagle project, I was actually aware of, so that is something I'm happy to bring into further submissions. Okay, Mr. Mundell.
Yes, it was just to apologise. I'm going to have to leave at this point as I've got another sort of pressing engagement, but I don't think that there's any other matters where you'd be hoping to hear from me, and I'll make myself available, as per your decision, in terms of where I fit into proceedings. But thank you for today. I'm sorry for being rude and leaving.
No, that's fine. Okay, thank you for your participation. I will produce a detailed note so you'll be able to see all the outcome of any discussions that happen beyond this. Okay, thank you. Right, so looking down on the further written submissions, so I've raised a number of matters that I want to cover. So around ecology, now just to highlight, there's a particular property that I'm going to ask the applicant specific questions. Majority of these questions will be asked to the applicant first, and then any other parties will be asked to involved or interested on these. So I want to get some clarity as to which other parties need to be involved in responding to the applicant's initial response on these particular topics. So impact on backs, I have another party that will be responding on that. Relevant information to assist the determination. This is the appropriate assessment of the potential effects on the River Tweed special area of conservation. This is an area I felt that perhaps wasn't covered in the submissions made by the applicant. Mr. Hardy, is that clear what I'm going to be asking the applicant for?
I mean, our general view, just cutting this short, is our view is that no further procedures are required on any of these topics. Obviously, then subject to what you want. Our job is to assist you. So but our view as a blanket is that nothing further is required.
Yeah, it's matters. Some of it's clarification, some of it's a bit more explanation, some of it may be pointing me to the right parts of the environmental impact assessment report that I'm, given the weight of documentation, and that there was additional environmental information as well. So it could be a combination of things. This is why I'll put in a separate procedure notice so I can hone into what I'm looking for.
Yes. I think as long as if you can be as specific as possible, because the general point I've made. So if we're wrong on that, or you feel you need help, then if you can signpost us to exactly what you need, that will they'll obviously will help.
Okay, on the list of other further written submissions there I've listed in the agenda, any individuals that are here today, any parties represented, are there any particular, am I just directing all this to the applicant? Are there any topics here that others would want to come back on in relation to the very specific things that I've highlighted, not general topic around these particular headings, but these very specific matters that I'm going to ask the applicant to come back on? If anybody could raise their hand at any point at this stage. Okay, right.
Milady, I was just wondering if I may ask, is the immediate impact on the development, if it's granted, on properties that are going to be significantly affected by the development in the short term, and of course during the lifespan, which I think is significant time period to be considered. Thank you, Milady.
Sorry, when you said, Mr. McClimate, when you said impact on property, in what sense?
In desirability, in living within the community area of the development, the effect that it may have on property prices in the immediate and long term, and the noise factor that may also dissuade people from moving into the area.
Okay, this is not a matter that I was going to explore in further written submissions.
Well, I'm sorry I ventured off. I went off at a tangent here. I didn't intend to do that, but it was really this is I think it's 40 years, which is a significant time span. I don't think that's that has to be considered by yourself, Milady. I don't wish to try and lead evidence or anything such like, because I'm well aware that no evidence can be put forward today. But it was just as a matter of this is a long-term project. It's not a short-term. Many people who are at this inquiry today won't be around. I don't know what the planners will decide. I'm not suggesting, but whether there's going to be reinstatement in the conditions. But what is clear that many of us here today won't be around when it comes to the termination of the time span that's being investigated in this inquiry.
Yeah.
I hope my point is at least considered, Milady. Thank you very, very much.
Okay, your point is noted. Thank you. Right, I'm going to move us on. I'm conscious of time and want to get through the agenda. We have got through quite a lot of stuff, and I just want to wrap up a few matters that are still outstanding. So, submission of documents. So those taking part in the inquiry, and I touched on this earlier, and the hearing sessions will need to disclose their cases, the cases that they intend to lead in advance. It's very important that you do that so everybody is aware of what matters are going to come up in advance. And I'm aware as well in preparing for the inquiry. Now, this is done by the submission of written statements, precognitions and other information. There are different documentation depending on what sessions you're going to be involved in. For those who are unfamiliar with inquiry procedures, I said I would just say a little bit about what an inquiry is and what a hearing is, and I kind of touched a little bit on this earlier. So an inquiry is a formal process in which parties lead witnesses on a particular topic and who may be cross-examined by other parties. And there's an order in which people go forward, which I won't get into here. So if you're taking part in an inquiry, you're required to submit an inquiry statement setting out the full particulars of the case that's going to be lodged, and that's made in advance by every party who intends to participate. If you're going to give evidence at the inquiry session, you also need to lodge, the individual witness needs to lodge a precognition. Now, this is normally lodged 2 weeks before the session starts, and we talked a little bit earlier about the cultural heritage session. That can happen a little bit later, 2 weeks before the actual session itself in August. I'll set all the dates out for when documents are due to be submitted in my note. Now, to save time at the inquiry, we would normally take precognitions as read, so you wouldn't need to read out your precognition. Everybody would have had that in advance and had the opportunity to read it. So really the inquiry would just get straight into the witness's statement and an actual cross-examination. Now, a hearing's quite a bit different. It's a structured discussion. As I said, I would normally set an agenda. It's led by me and based on an agenda that I would circulate in advance. Parties involved in a hearing would submit a hearing statement and also any supporting documents, all in advance. Again, timescales will be set out. I would lead the discussion, starting each item of the agenda with a question to one or other of the parties, those people that I need to get the information from. Once I get an answer, I'll move on to the next item. And it is about me just gleaning and getting the information that I need in order to write the report for the Minister and to highlight where the differences are between parties and understand that. So that's just a general overview. There's more details about inquiries and hearings in the Code of Practice that's linked in the agenda, and also information on the DPA website as well. But if you go to the Code of Practice, it'll tell you a little bit more about how inquiries and hearings operate. Now, just moving on to specific documents, I highlighted a few things in there about things that are needing to be submitted. This is probably more for the applicant's benefit, but just to let you know, Mr. Hardy, if you've been involved in inquiries recently with the DPA, we've developed a kind of core documents list that enables, rather than have duplicates of the same documents being submitted by multiple parties that you're all referring to, the idea is there would be a core documents list that's developed by us that already sits on our systems that you would link to with a hyperlink in your submission. Now, our office can assist with that. Fiona Manson in our office is the person to speak to who's developed that system. And it's essentially a library that you can access and link to all the documents to present as evidence. What we would ask the applicant to do, who's kind of the key party in this, to take the lead on this, ideally, is to provide a single core documents list that's produced in liaison with the council and the other participants that you all then link into. And that would then avoid the need for the kind of duplication that I mentioned.
Ma'am, I don't know whether this is helpful. Yes, of course, aware of the procedure, but as I hope Mr. Campbell and Mr. Armstrong will support me in saying, at Sanka, CMS have got fairly elaborate IT. They produced a collaboration site which was made accessible to anybody that wanted to get onto it, and it worked extremely well. And therefore, what we were going to propose, if this is helpful, is to do exactly the same thing for CMS on their site to host everything, all documentation. And if that was acceptable to you, then that's what we would propose to do here.
We need you to check that with our office. I don't know when was the Sanko inquiry, or when did that take place?
At the middle part of last year.
We've probably moved on since then, actually, in developing our core documents. So it's just about whether there's, the process we've got now in place might facilitate something that's more kind of in keeping with how we're going forward.
Then of course it was an offer. It worked. It was extremely good and easy to use. It's offered again. If there's something that you want us to use, then I should just ask Mr. Keith Campbell, who's on this call with CMS, to get in touch with the unit, and they can liaise.
Okay, that I'll leave that to you. That's probably the best thing. Mm-hmm. The best thing to do at this stage. And Fiona in the office will keep you right. But I'd really encourage you all to use that system. It's a much we're all then operating in the same documents, same references. Doesn't get confusing. I've been at Caparis where various things have been referred to that various documents have overlapped and different numbers, and it can be extremely confusing. Mr. Armstrong, did you want to come in?
Yes, just to say that the preference for the council would be to use the DPEA core document system, which I think is the way forward, and I think it's easier also for members of the public to sort of work around as well. So that would be a strong preference for the council.
Just in backing that up, I think it's one of the reasons why we've developed it. We realised there was a kind of missing, need for something like this. So. Thank you for those comments. Mr. McClymont, you're on the call. I just wanted to check with you, Alexander McClymont. You've asked for hard copies of any correspondence as you don't have suitable access to a computer. Can I just check with you that did you want everything in hard copy that's relevant to your concerns, or can you manage with accessing some of these documents that you can look at? And obviously I'll send the note of this meeting, I will send out in hard copy to you. But beyond that, how might you manage?
Well, it's very difficult, lady. I mean, organisations, the applicant, and major representatives have, highly resources. I'm a retired person, and it's very difficult to. I don't have a computer as yet. I'm trying very hard to get access to a computer, but in the meantime, at the immediate situation here. As I'm speaking from Girvan, is that I'm using a mobile phone today, and I'm very, very fortunate that my son has provided that for me. So I'm able to participate. Otherwise, I wouldn't be able to participate. Now, the case officer has really, really excelled in sending documents, in some cases first class, to my home here in Girvan. So I must appreciate the fact that she's done all that for me. And I would continue. It helps me to be able to physically look at documents, other than the size of a mobile phone. It's very difficult. Yes. So I would request, where possible, that hard copies are available to me, especially the important documents.
Right. Well,
I hope that's enough information, milady.
Sorry to interrupt you. Yeah, we will endeavour to do that. If circumstances change and you manage to get a computer connection that works for you, then please let us know, because keeping track of everything is we rely so much on electronic communication, and I suppose that's just the way that the world is now. But we will endeavour to send everything out to you in hard copy and I'll ask Marie to note that.
Extremely grateful, my lady, extremely grateful indeed, and I'm very grateful to be able to participate today, because it's a huge learning, even in my old age. I think I'm a young person, but even in my old age, I think this is a learning experience. So it's a great part in this, and I know I maintain that I'm God's representative, and not representing any other party at this inquiry. Thank you so much.
Okay, thank you. Right. Moving on to statements of agreement, we touched on some of the stuff. So I've highlighted some of the matters that maybe need to cover by an agreed statement, and I would encourage the applicant and other parties to work on really honing down what the agreed matters are, so that we can concentrate on those matters that are in dispute and where those differences are. Just covering what topics that might be covering, so around policy and development plan policies and supplementary guidance, and just agreeing with the council as to what are the relevant documents in those areas. Any conditions, obviously, that the ministers are, if they're minded to grant consent. We've ruled out any agreed matters through a legal agreement, any agreed matters around landscape and visual matters, And we talked earlier about the MOD, Eskdale Muir. There might be some matters of agreement there in relation to some of the issues that are going to be discussed at the inquiry, or not required to go there. So, sorry, Mr. Hardy, you've got your hand up, and then Ms.
Yes.
Milne.
All of that absolutely will be supportive of statement of agreed matters. However, in order to make those effective, we do think that the 16th of March deadline is too early because, you can tell from the state of play really on this call. I think that in order to be most effective, we're suggesting mid-April for drafts, final SOAMs by mid-May, which is about 4 to 6 weeks before the inquiry starts. So okay. Yes, absolutely. Just please, could we have a little bit more time? Mid-April drafts, mid-May final ones.
I'd actually, in my notes, I'd moved it on a little bit, not as far as mid-April, but I'm happy to move it onto there. I'd moved it more onto the end of March and then into the kind of end of April, but happy to move it to mid-April, mid-May.
Thank you.
Okay. Mr. Milne.
Mr. Hardy stole my thunder there. I was going to say, in terms of statement of agreed matters, particularly for the MOD, that's very tight. We're obviously still in this stage of discussion around the report. But the other thing that I was going to ask, ma'am, in terms of the date for lodging documents, that's the same date as lodging of inquiry statements. I wonder if, in order that inquiry reports lodged as documents can be fully informed by parties' positions as articulated in their inquiry statements, it would be possible for inquiry statements to be lodged a couple of weeks in advance of the lodging of documents.
Right, I've got a provisional date of inquiry statements coming in 8 weeks before the inquiry, so around the 2nd of May. You're right, that coincides with documents. So you're suggesting maybe bringing that forward a little bit and then the documents following on after that?
Yes.
Right, let me just get my diary.
If I may say, what we would propose would be, as with the SOAMs, the same for the final list of or the core and parties documents, final draft conditions, inquiry and hearing statements. What we would suggest was 4 weeks before the inquiry sessions. So mid to end of May, we say that still would allow plenty of time pre-inquiry. So I'm not averse to a separation, a staged submission, but again, trying to give a little bit more time. It feels incredibly tight to us.
Sorry, just run that past me again, Mr. Hardy.
Yes. So as with the SOAM, same for the final list of the core and parties documents, the final draft conditions, the inquiry and the hearing statements. What we're proposing would be 4 weeks before the inquiry sessions. However, I'm not averse to a separation or of a stage that in the way that Mr. Milne has suggested, but I just think all these dates, all the indicative dates that you'd given, need to be put back because the timetable feels very tight.
Okay. Let's have a little think. There's obviously some flexibility around the cultural heritage anyway, which is, we can push that. We're pushing that a little bit longer.
Yes, that's very helpful. 2 weeks, so before the,
2 weeks for precognitions, and for the inquiry statements, we said 8 weeks before the inquiry starts. So would it be, I'm just thinking the best way to do this. I want to make sure everybody's got enough time to produce documents, but I don't want to leave things so tight that people don't have enough time to tell it. As the lead up to the inquiry, as I've always found, is that things start flying in, and it's potentially, I'm not looking to take rebuttal statements at this, and I don't particularly would encourage anything like that, but it's inevitable that things might pop up that might need my attention.
I think that the frequency of rebuttals and the frequency of additional things just increases. That if the more pressure you put on at the front end, things just experience indicates it's a balance, isn't it, between going too soon or too early. That's really the point I'm raising. We just think it is a bit tight, and our proposal is 4 weeks before the inquiry sessions.
For the inquiry statements, 4 weeks. For the hearing statements, 4 weeks.
Yeah.
For the documents.
Yes.
4 weeks.
Same thing.
Yeah. Okay. Mr. Campbell, you've got your hand up.
Yes, just to agree with Mr. Hardy, really, and to make sure that the parties constructing the statement of agreed matters do remember to include the community group. We have a diffuse range of interests, Many of them can be agreed, but some of them will not, and you'll need to know which those are. So
yes,
one tends to forget third parties. Please don't do that.
Okay, thank you. Mr. Armstrong.
Yes, I'm happy, Ma'am, with the idea that the inquiry, the documents and the inquiry statement should be at different times. But I do wonder if we're having, which inevitably we will have for the landscape and visual session, there will be an inquiry report produced, which will set out detailed evidence. We then, Mr. Hardy seems to be suggesting that thereafter an inquiry statement is put in, and then after that we've got the precognition. I wondered, should the inquiry statement though not come before the inquiry report? Because the inquiry statement is sort of setting out the key points that are going to be dealt with. The inquiry report inevitably will, certainly for landscape and visual, set out the detailed evidence, and then the precognition sets out the sort of key points. I just wondered if perhaps if we have the inquiry statement after the inquiry report, really what's the purpose of the inquiry statement?
To be honest, I'd taken the inquiry statement as the inquiry report. I hadn't got a separate stage requiring an inquiry report.
Well, it would normally be, I suppose, that it would be the inquiry report setting out the details would come in certainly in my experience with the documents, exactly. And that's certainly been the case with the last half dozen inquiries that I can think of that I've been involved with at least. I know that there has been in a couple of inquiries that I've been involved in that there has been no inquiry statement. I think they do serve a purpose of focusing what the arguments are going to be. But could I suggest that if we are going to have an inquiry statement, that it comes before the documents are lodged?
Can I suggest the inquiry statement's kept at 8 weeks before, and then we have an inquiry report with the documents at 4 weeks? Yeah. Right, I'll build that into the timescales. Apologies, that might be quite confusing for people, but it'll all be set out. So, and it means that everybody knows what the submission timescales are and what they need to do. Any more comments on that? So, closing submissions, precognitions would happen 2 weeks before the inquiry. Then we've got closing submissions. Normally, you would submit your closing submissions 7 days after the inquiry has ended, the final date of the inquiry, which would be now into August. That's for all the other parties, and then the applicant would submit another 7 days after that. The applicant would submit their closing submission. Does that sound reasonable, given that the inquiry is running on until August? That we don't perhaps need to extend that beyond the 7 and the 14 days?
The only thing I'd say, it is holiday season, and my just experience indicates trying to get instructions and experts in August is difficult. It might be that we just need a bit more time.
If it transpires at the inquiry that we need more time, then we can build that in at that stage and add additional opportunity to come back. If people are able to submit them within 7 days, great. If they need longer, then we can do that. And then ultimately, your final response would come in on the back of that. Okay, we'll know better when we're into July and August. Okay, Mr. Armstrong, your hand's up. I presume you've not got a question at this stage? No, okay.
We also just need one final deadline is for you to consider your when you want the cumulative the L&V material in relation to the regulations.
Yeah,
so
yes, of course, the additional environmental information. Yeah.
Yeah.
Yeah, I don't know what the timescales for that will be under Regulation 19. I'll need to just check on how long that will need to take.
And also a question of how quickly it can be done as well, because let me just try and find that out. But I'm just flagging it up that that's a date that will need to go into the note.
Do you have an estimate of time to finish that bit of work?
I think Mr. Welch messaged me earlier on, so I'm just looking through the messages to see what his answer was.
Okay. Right, I'll just move on to site inspection just while you're looking. You can come back to me on that. So I intend to carry out an unaccompanied site inspection in advance of the inquiry, and I haven't arranged when exactly that's going to be yet, but that's just so I can understand the site's context before I get into any detailed sessions when I'm hearing evidence and I've actually seen the site and I'm aware of what the issues are. I'd like to know at this stage if there are which particular viewpoints potentially could you want me to focus in on. Obviously, there's 20 plus viewpoints. Can't remember exactly how many there are. Some of which are obviously more poignant and relevant to some people's concerns than others. So I may put that down in my note of the meeting and just ask for people to come back to me with any suggestions as to particular viewpoints, and I'll just concentrate on the key parties being the council and the applicant at this stage, given that they originally were involved in the choice of the viewpoints, I'm assuming, in the scoping stage. Mr. Campbell, did you want to say something there? Oh,
no, ma'am, sorry. I thought I'd turn my microphone off. Sorry.
Oh, it's okay. Then the idea is that we'll have an accompanied site inspection. I've provisionally put the date for that down as the very last day after all the inquiry sessions are concluded. So that will be on the 12th of August. That will be accompanied. It will be dependent on any restrictions in place at the time. And if physical distance is still in place. We are doing accompanied site inspections now at the DPA. So by the summer, I assume that things may be a lot more capable of doing those in more fully. Got the date, the 12th of August. I just asked the applicant at this stage just to be thinking about any site preparations for that. You know, what route we might take, where we might go. It's probably a little too early. And then our office will contact parties to see who wants to be attending that. To get an idea of numbers.
We're very happy in the normal way to try and liaise with the other parties to come up with a proposed itinerary and to make the arrangements for that. So that's something that we will do. Mr. Welch has come back to tell me that he thinks it's going to be mid-April for the additional L&V work to be done.
Mid-April.
And just in terms of the viewpoints that he thinks, off-the-cuff viewpoints that he thinks you should go and see, you should focus really on those within 10 kilometres. But that's just on the hoof. We need to give it more consideration, and there will be a proposed itinerary drawn up for you.
Okay, that's helpful at this stage. Right. Right, just moving on to just miscellaneous matters, just wrapping up a few things. The venue for the inquiry, the office will look into that. I've made a note about the suggestion of the hall in, is it Langham, I think, was suggested? Is it the Buccleuch Hall in Langham was suggested? Mr. Milne, you've got your hand up, sorry.
Yeah, sorry, ma'am, a very brief point about the site visit. I'm told that you may benefit from visiting the Useley's Watchtower site before the grass grows significantly, as it will do over the summer. Looking at a site visit in August, the area might be quite overgrown, so perhaps an unaccompanied site visit earlier in the year would be of benefit.
I've noted that. Okay, thank you. Mr. Moffat? Just with regard to Useley's, I've got some good photography of the site and some of the archaeology up there. Okay. And if you wanted to walk up, I would walk up with you and tell you a bit about it as well, if you like. I'm afraid that can't happen just the two of us together, I'm afraid. But what I could do, if I felt I needed some more information, I could ask you to provide some information. Obviously, you'd need to share that with the other parties as well. But if there's something that might assist my understanding of it. If that particular site's of incredible importance, it's about a 20-minute walk. Okay. I can take you up there. There's prehistoric fortified avenues going up to what might be a Bronze Age or a Roman watchtower. But it's quite an accessible walk, and you'll find it rewarding in terms of history and archaeology. Thank you. That's useful to know. Mr. Armstrong.
Ma'am, just two brief points. I think the Buccleuch Centre is mentioned as one possible venue. It does have some availability during these times. There's a couple of days that are not available. It's certainly been used for major inquiries, a flood prevention scheme inquiry in the past. There is also, Ma'am, the Crown and the Eskdale Hotel, both in Langham. They have function suites, and my understanding is that they also have availability for the relevant dates. And one other point, if it could be possible, I don't think it does hit any of these deadlines, but if the week of the 4th April could be avoided for having to lodge any documents, etc., I think that would cause logistical problems for Dumfries and Galloway Council if that was a key date for lodging or producing documents.
Sorry, Mr. Armstrong, the week of when? The week of the 4th?
The 4th April.
4th of April.
I don't think that is a problem looking at the time scales that you were envisaging, but if that could just be highlighted at this point.
Yeah, I was looking for a core documents list, but I'm gonna give you a bit longer to produce that actually now. So rather than 12 weeks before the inquiry, I'll make that 8 weeks. Okay, that's fine.
My lady, if I may speak.
Yes,
Mr.
Climate, yes.
As regarding site visits, I just wanted to make one suggestion, was that on a very clear and suitable day, that you have an opportunity to view the site from an aerial view, unaccompanied. Thank you very much, my lady, for my suggestion. And
sorry, I didn't quite catch that. Did you say an aerial view?
Yes, a flight, in other words, an aviation flight on suitable weather, so that you can see the whole site from an aerial point of view, rather than all those individual 20 points I think you mentioned. It's only a suggestion, my lady. It's not. I'm just hoping that someone might give you the opportunity to do that. You know, some generous person might provide you with an unaccompanied, obviously, aerial view of the area.
Yeah,
thank you so much, lady.
Thank you. I think viewing the site from a number of aspects is very important, and also viewing it from where people will walk and travel and all sorts of aspects is an extremely important part of the site inspection.
I agree with you so much. Okay. But I think if the opportunity arises, an aerial view will put those all into context.
Okay, thank you.
We have aerial footage available for you to see, which hopefully we'll be able to demonstrate.
If Mr. Moffat, I'm sure you've got lots and lots of information, and some of it may be really useful to me. And I think the difficulty is if I'm thinking that I need any additional information, I'd need to ask you to provide that, and obviously to provide that to parties. I can't be giving myself evidence, and it's important that I ask for that at the appropriate time. If I feel I need anything further, I can come back to you. If I can just focus back on the agenda. So we've got, we do webcast cases, and we try and do the cases where there's most interest. I'm absolutely sure we'll be webcasting this case. So the inquiry sessions will be re-recorded as today. Obviously, I can't guarantee that. It depends on availability of our own internal staff, but we will certainly endeavour to do that for this. All relevant documents associated with the case would be required to be placed on public deposit. By the time we get to the summer, it's possible that the councils might be in a position and be able to, the restrictions would be lifted in terms of being able to place the documents, hard copy documents, on public deposit in a number of locations. But our office can liaise with the councils on where and how that might work. If any remaining COVID restrictions are in place, we might have to think of an alternative. At the moment, we're not placing. We just rely on the DPA case management web page where we hold all the documents, and that would have to be the alternative. You can view all the documents on the DPA website, as I said, and we maintain the website. Marie puts everything up there that's publicly displayable, so keep track of what's happening by following that website. The case reference is WIN-170-2007, so you can get everything up on that. The note that I produced of this meeting is effectively a procedure notice for the purposes of the set out in the Code of Practice. So it initiates the procedures that commence the inquiry process, just so you're aware of that. But I will follow it with a formal procedure notice, picking up all these other matters that we've raised in terms of the further written submissions that need to be covered. Okay, I think I've covered everything on the agenda that I wanted to cover today around procedures. I'm conscious it's taken a long time. I really appreciate your time today and getting through all of that. We've reached the end of what I need to say. Are there any other relevant matters in terms of what we've discussed today with regard to procedures? Anything that anyone's not clear of that they want to raise before I finish up? I'm just looking for any hands going up. Okay, all right. That's really helpful. If there's nothing further, that concludes the pre-examination meeting. As I said, thank you for your contributions. And if there's any queries, anything that pops into your head that you want to ask, get in touch with Marie at the office, and she will direct your questions to me if there's something that you need to ask me. And like I say, I'll have a note of the meeting produced within 7 days, ideally from today. Okay. Well, thank you very much.
Thank you very much.
Thank you. Bye-bye.